Morning, Commissioner.
Morning.
I'd like to open the hearing by acknowledging that the City of Hamilton is situated on the traditional territories of the Erie, Neutral, Huron-Wendat, Haudenosaunee, and Mississaugas. The land is covered by the Dish with One's Dune Wampum Belt Covenant, which is an agreement between the Haudenosaunee and the Anishinaabe to share and care for the resources around the Great Lakes. We further acknowledge that the land on which Hamilton sits is covered by the Between the Lakes Purchase 1792 between the Crown and the Mississaugas of the Credit First Nation. Many of the council appearing on the hearing today are in Toronto, which is in the traditional land of Huron-Wendat, the Seneca, and most recently in Mississaugas of the Credit River. Today, this meeting place is still home to many Indigenous people across Turtle Island, and I am grateful to have an opportunity to work on this land. Commissioner, today we have our next witness, Diana Swaby, and she has not yet been sworn.
Would you raise your right hand, please, ma'am? Do you affirm the evidence you are about to give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Good morning.
Good morning.
Just before we get started, I've heard your last name pronounced two different ways. Is it Swaby?
Swaby, yes.
Thank you. Ms. Swaby, I'm going to start today with some questions about your professional background and employment history. I understand that you've been employed with the City of Hamilton since 1989. Is that right?
Yes.
And are you, what is your current position?
My current, technically I'm called acting manager. But for the, since 2012, I've been claims supervisor, but I was sort of put into that position due to some transition in the department.
So you're currently acting manager, and that's within the Risk Service Management Services Department?
That's correct.
And that services department, that's within the legal department, is that right?
Yes, it would be the Legal Services Division. Risk Management Services is a section of the Legal Services Division.
Thank you. And you've held that acting manager role, you've said, since a period of transition. You've held that role since November 2021. Is that right?
Yes.
And am I correct that Mr. John McLennan, pardon me, held that role before you?
Yes.
And you took over from him?
Yes.
And you said just a moment ago that you've also been acting as a claims supervisor.
Technically, my position was claims supervisor as of 2012, and I held that role until November of 2021.
Thank you. And prior to that, from 2006 to 2012, you were a risk management analyst within
Yes.
risk management?
Yes.
And before that, back to 1989, you were a law clerk in the Legal Services Division. Is that right?
Yes.
What's your educational background?
I'm a graduate of the legal assistant program from Niagara College back in 1986, I believe, 87.
The queries received some documents that appears to refer to you using a different name. I think an earlier name, Diana Sabados. Is that right?
Yes.
When did you change your name to Swaby?
2015.
Thank you. So I'm going to start with asking you some questions about your, in fact, most of my questions today are going to be about the period of time between 2012 and 2021 when you were, I have you down as Supervisor of Claims Administration. Was that your technical title?
Yes.
Okay. Who did you report to in that position?
John McLennan.
And who reported to you in that position?
The three claims representatives, technically.
What were your primary roles and responsibilities? Pardon me, I think I misspoke. What were your primary roles and responsibilities in the Supervisor of Claims Administration role?
Dealing with claims, investigation of claims received by the City of Hamilton that were covered by its insurance program, ensuring assigning them out to claims representatives, as well as for the claims risk management analyst, my former role. They received claims as well. And I provided a leadership role to the analyst position, although technically on paper, the analyst didn't report to me. They reported directly to John. That being said, so I was really an intake person. So the majority of the claims that came or were being pursued against the city would come to me first for proper assignment. So I would assign claims to myself, to John McLennan in some cases, depending on the types of claims and the volume and workload, the risk management analyst, as well as the claims representatives. We all had claims under our carriage.
Thank you. So just stopping there, when you say claims, as a lawyer, I hear legal claims like there's been a statement of claim issued. Is that what you mean by claims, or is it something broader?
Much broader than that. It could include a notice of a claim being contemplated, could be the initial contact, and eventually a statement of claim may or may not ensue thereafter. But my responsibility was to investigate notice of those claims when they arrived, if they were covered by the city's policy of insurance.
Thank you. And so when we're talking about your definition of claims, what you were dealing with, roughly how many claims per year was risk management responsible for administrating?
I didn't keep a running total of them, but I can say that there were hundreds, if not thousands. I would estimate somewhere between 2,000 and 3,000 claims that might be received in a given year. And those numbers could go up and down, sometimes because of weather events.
When you assigned claims to, I'm going to say staff, so the risk analysts, the supervisors, yourself, Mr. McLennan, how did you determine who would be assigned to which claim?
Typically, because we were a very small section, and recognizing that we had a high volume of claims, the process of assigning them might have changed over the years, depending on who was available and their area of expertise. But generally speaking, the property claims, so third-party property claims, so for property damage, those were all typically assigned to the 3 claims representatives. So in addition, they had their own portfolios as well, different client groups where, for example, the HSR, that was quite a large program. So one individual claims rep was responsible for that. Another claims rep had a subrogation unit under their area. And the third one also had, there may be collision claims and so forth. So they all had their own, but in addition that they would work on their own, but insofar as third-party liability claims, when I talk about those, that was my primary area of responsibility. Property claims were being assigned to the claims reps. The odd personal injury claim, the less complicated ones, if you will, would go to some of the claims representatives. But for a time period, there was a considerable bulk of the personal injury claims that I assigned to myself for a period of a few years. And so we also had external adjusters that we had that did a lot of the groundwork for us, the investigation, just because of the sheer volume. We did not have the manpower inside to do a lot of them, do that field work ourselves, that adjusting work, the communications with the claimant or their counsel. But the property claims could be dealt with internally on their own. They were generally smaller. They may take you could investigate them quickly. There's a determination made. So certainly more of them, but opening and closing them. So they were less involved. Whereas the personal injury claims, they may go on for years, depending on that. So for a considerable time period, I had a very significant caseload. And so that was important that we use the external adjusters to do much of that work for us so that I could cover more ground, so to speak.
Thank you. So thank you for that answer. Just within it, you mentioned a large program called HSR. Just for the record, what does that acronym stand for?
Hamilton Street Railway. That's our public transit service.
So you said that you were dealing with the third party liability claims. Did that include claims related to the Red Hill Valley Parkway?
Yes, they did.
Okay, I'm just going to step away for a minute from claim supervision. Did you personally, in your prior role, have any responsibility for negotiating the city's insurance policies?
More on a peripheral level, I'll say that because oftentimes when you're completing the process of renewal or securing insurance, you look at claims histories, you look at reserves, what were paid out before, what the Hamilton's claims experience is prior, is an integral part of that process. So I was often involved with the claims, the disposition, the history, and to address and talk about some of the issues in those claims as part of the overall renewal process. So if if the insurers or prospective insurers had questions about loss runs, I was called upon to provide that information.
Thank you, but you otherwise didn't have any responsibility for that negotiation?
No, not until of November of last year when John McLennan was no longer there, and I was able to step in and assist with that.
Thank you.
Oh, the other thing I should mention as well is I was also responsible for what they call the insurance notice program. So it was important for the city to report claims in a timely fashion to the our insurers, the city's insurers, to ensure that coverage was also in place if we had exposures that were in excess of our self-insured retention or deductible, depending on the policy that was in place over the years.
Can you ballpark how many claims of the between 2000 and 3000 related to third party liability? A much smaller subset than the property claims you were talking about before?
It would have been less than the number of property claims for sure. I couldn't give you an exact number, but I'm going to guess, maybe around I don't know, to be honest, between 500 and 1,000. It really depends. If you had a really bad year, for example, one year we had the polar vortex that descended on the city back in 2014, you might get 100 or 200 claims over what you normally would. So, but generally speaking, definitely higher. The majority were smaller property claims like tree limbs falling, pothole claims, sewer lateral backups, smaller property claims, definitely many more of those.
Thank you. So you said earlier that you assigned the claims, you're an intake person. Did all the claims that came into risk management cross your desk?
Not necessarily, because we would receive them through various sources. So from a purely technical standpoint, my preference is that every claim would be served on the clerk as per the Municipal Act. And they are the keeper of records, and they do track that. But that is only one, and they should be in writing, but that is only one way that we would receive them. We would often receive them perhaps from other departments, such as the counselor's office. They may receive a call or a complaint, and that might get directed to John McLennan and then eventually come to me. We also have an email account, for a risk email account, that sometimes claims would be submitted via email. And later on, I became involved with monitoring that, but for a considerable number of, I'm not sure when it actually was implemented, but I didn't start reviewing those until much later, 2018. They could also come in from other departments. We were also proactive in the sense that if there was a call, we received, a lot of times risk management receives calls and complaints that are not necessarily relating to claims. They may be a complaint. So if it was an operational matter, I have a problem on my street, I'd like to have it addressed, we might forward that off to the Public Works Roads Department. If a mailbox was taken down, that might go to somebody else to deal with. Someone had a complaint about noise, that might go to the municipal law enforcement division. So a lot of times we would receive emails from a variety of sources, and we would certainly assist the public with having their complaints addressed, in addition to dealing with claims. So sometimes we might get a complaint in and say, I fell over here and I need the sidewalk fixed. They may not submit a claim, but I may proactively go and have a field investigation completed just to make sure that we get some pictures of what it looked like before potentially a claim could come in.
On that, given that you either received claims, or you may have been receiving public complaints or concerns, were you aware of concerns from the public about the Red Hill Valley Parkway?
No.
I'm going to say sort of between its opening to when you took over your new position.
Typically speaking, when we conduct any investigation for a claim, we will ask for a history of complaints for a given location. So sometimes,
I'm sorry to interrupt. From whom would you ask for those complaints?
Whoever well, it would depend on each given claim. If we were talking about the Red Hill claims, we would be asking for a history of complaints concerning the Red Hill and how they were addressed over the years. That's part of it. A part of our review, when citizens complain about a potential intersection or a concern they might have, how Public Works would have addressed them as part of our review.
Who would you ask for the Red Hill in particular? From whom would you ask about a history of complaints?
Well, it depends on, there are a number of different sections. So we have in Public Works, so we have the operations roads staff that deal with potholes, spills, cleanups, clearing the road of snow. That's one particular section. There will be another section that would be traffic. They might be dealing with, they would deal with road and pavement markings, signage, speeds, traffic controls. Then you also might potentially also have the original design group. Those might be three different areas in Public Works where there may be relevant documents that form part of the overall investigation. In more recent years, there is now a coordinator at Public Works who is an intake person as well, that now oversees the dissemination of all the types of requests that we have. They make the inquiries now to the various sections, compile the information and bring it to us. But it was not always that way. It has changed over the years as people have come and gone, where those requests would go historically.
Thank you. And that intake person, that is been since just in the last few years, couple years?
Yes, it's very recent.
My initial question was, were you aware of complaints on the Red Hill during your time as the supervisor of claims administration? And I'm not sure I quite got that answer.
Was I aware of complaints? I know that as a result of the substance of this inquiry here today, that there were complaints that were voiced by citizens.
And did you receive any of those complaints?
No.
Okay. And you said that at least I understood from what you said, that your process would have been to ask for a history of complaints.
Yeah.
Said where you would find it. Did you actually ask for that in this case? Because we don't have any documents to suggest that you did.
It would be in the form of, we would ask for Hansen records. So if a complaint came in, it would be logged on Hansen. That is my understanding how the complaint system would be documented by the operating client departments, how they're able to address them. They log it. They could create service requests. That's how they keep their documents. So if I asked for, can I have a history of complaints? They would, depending on the department, and in this case, Hansen would be the one for Public Works. That was my information. They would search and look for anything. And I know Hansen was a very robust program. They logged, I had seen it before on other claims where they would log everything as far as something as simple as my house shakes when a bus goes by. Something as small as that, or my blue box is gone, or anything and everything was typically captured on Hansen.
Thank you. Let's talk about what you did as a claims supervisor, if I can put it that way. So your work while you were the supervisor of claims administration, but when you actually were dealing with claims that you'd assigned to yourself. What were your practices upon receipt of a claim that you were going to oversee?
If we were dealing with personal injury claims, myself, the first thing I would do is I would assign an external adjuster immediately as soon as I had it. And it was their responsibility to acknowledge receipt of the claim with the claimant and or their representative, saying, I am the adjuster that has been assigned to investigate this claim. And they would be responsible for communicating with the claimant or the representative through the course of the investigation. So the external adjuster would, and when I assign the claim, I usually provide some, not always, but in some times I might provide some preliminary thoughts or comments that I might have, just really just on its face, just to provide some direction. If I have some concerns with the notice, I might indicate that. If I had an issue with the notice in the sense that it didn't comply with what was expected under Section 44 of the Municipal Act, as far as providing enough information about the location so that we could and get the information that we need, the documents, the pictures, and so forth, I would provide those instructions to the adjuster. And then eventually what would happen is I would start receiving their reports on, as their investigation proceeds, what documents they've received, what their review of them, what further documents are needed, what further investigation is required. I I would eventually review them as it moves forward and provide instructions at times that it was appropriate or required to do. For example, should we interview these individuals or should we not? And eventually there would be a determination made, or we would, once we just determined whether we had enough documents, in some cases we would either decide to deny a claim, or we would potentially consider offering some compensation if we had identified some legal exposure. And eventually, if a statement of claim was issued, depending on the outcome, if we thought it was a denial or not, it would go to the hands of defense counsel as well. And as that information is gathered and gleaned, I glean from that what the significance of the damages are, how serious the injury is, also consider whether or not we need to put the insurer on notice and bring them in the loop, so to speak, to ensure that we don't prejudice its position to defend the matter as well, and to make sure that we secure everything that we can.
Thank you. I will come back to the process that I think you set out about how you work with adjusters and generally run through up to the point of a statement of claim. Just before we get there, you said that you start by assigning an independent adjuster. Is there also a file opening process within the city software?
Yes, there's we have a software system called Riskmaster. I think it's called something else now. It's changed its name over the years. It's pretty out of date, but that is our system that we use. And we could all in the years gone by, we opened our claims ourselves on the system. Everyone who had claims had a user ID and could open the claims themselves. And in later years, when we hired a risk assistant, she took a more active role in doing that for us, to free up some time for us as well, because of the sheer volume of the number of claims coming in, and it being really an administrative function. It was great to be able to have another staff member to do some of that work for us.
What sort of information was inputted into Riskmaster?
Definitely the claimant's name, the date of loss, the location, as described on the notice letter, if we had it. Sometimes we don't have complete information, but certainly anything that we can take from the notice letter and input it onto the system, we would. So date of loss, a description of the event. There is a location where you can describe what it is. A motor vehicle accident, if that's what we're going to talk about today, is the Red Hill claims. The parties that were, whatever information is on the notice letter, we would try to put on the system. But definitely you need the data loss, you need the claimant's name and a location, the file handler who's been assigned it, who the external adjuster is, those, and as well, if there is an allegation about the cause of the accident that's there. If so, it could be design. Is it pothole? Is it slippery because of winter? It was a snow event. The client department, if you will, that's a crucial piece of information as well, because the responsible department is where those expenses are going to be charged back to eventually. So you need to make sure you have the right client group on there. But those are the really, I would say, mandatory fields, although Riskmaster does have the capability of adding other information along as well, if we could find the time to input that further information as the claim progresses.
So a question on that, recognizing the resource constraints, was the expectation that Riskmaster would be updated periodically through the course of the assignment of the claim when new information came in?
I think it's important. The important parts of Riskmaster are ensuring that you have the right client group for the purposes of charging back, so that the right department gets charged, because risk management is really a zero budget based department. Everything gets charged back to the responsible department. So you can imagine that if it ended up being something that was from the operational side, was it traffic or was it a pothole? That would be very important for the purposes of making sure that the funds were applied to the right client group. I think the other things that are really important to be consistent is making sure that locations are up to date, are updated eventually. Definitely the client's name. And I say this for the purpose of being able to run accurate loss runs later on, to be able to identify and capture all of the relevant claims. So certainly the more you can put in on a claim, the better. But really to come back later and to update every single claim with every piece of information, that was definitely a big challenge and very difficult to maintain. I don't think we had reached that. We certainly haven't reached the point. Riskmaster hasn't been that intuitive as well. As a very manual driven program, and we're working on actually getting a better software system to assist us with that. Excuse me, I'm sorry, I didn't know my phone was on.
No problem.
I thought I turned them all off, but anyway, I apologize for that.
What I'm hearing your evidence to be is that Riskmaster is not a repository where where one could go and find sort of the current status of a claim as it's progressed and all of the documents that have been received. It's not that kind of repository. Is that right?
No, it's not. And before the pandemic, we were a very paper-driven department. So you would rely heavily on the paper. We would print off our emails and we would put them in a hard copy file. Since the pandemic, obviously we had to move into an electronic world. We were forced to do that. So, and I have been trying for a long time to move more electronic. But to the answer to your question is no, yes, I guess it's the hard copy.
Not a repository. Okay.
Right.
I'm sorry to interrupt you. So I just have, I'm going to actually ask you about your other file practices, both hard copy and electronic. Just one last question on Riskmaster. You said that if there was an allegation about the cause of the accident, so pothole design, slippery, snow event, is that like a drop-down list or like a tick box list? Like are there consistent topics that one could choose for that?
Yeah, there are cause codes that you can choose from, and you do your best to choose one that you think might be the most applicable one based on the information that you have at the time, certainly on your notice letter.
Thank you. So turning now to your file management practice outside of Riskmaster, and I'm most interested in your period of time up to 2019, so pre-pandemic. You said you have kept hard copy files of your claims, and would that include pieces of correspondence?
Yes, so we would receive correspondence through the mail, and we would receive correspondence through fax, and we'd receive correspondence through email.
And you would print out your emails as
yes,
even though they're electronic. Okay. And did you have a correspondence brad or a correspondence sort of file that was kept in chronological order?
Yes, they would eventually, on some of my larger files, I started creating subfolders just because they got so large, it was difficult to navigate through them without putting them in some kind of semblance of order. So I did that for myself, but typically, yeah, they were eventually printed off and put in the hard copy file. It might take me a while because we were dealing with high volumes.
And I presume you'd also keep copies of pleadings when any were received or sent, statements of claim, statements of defense.
I get statement of claim. I may or may not get the statement of defense. It was not a requirement to get the statement of defense. If I received them, I did obviously have them. I would keep copies and I would make sure they would get to the defense counsel assigned on behalf of the city.
I was thinking about the city's own statement to defense. You'd have a copy of that.
Not necessarily, no.
Defense counsel might have a copy of that, but wouldn't necessarily provide it to you.
I don't really need it.
Okay. Would you include all of the reports that you got from your adjuster on the status of the investigation?
Oh, yes. And that would, anything and everything I compiled during the course of an investigation would be forwarded along to defense counsel assigned.
Okay. I'm just asking about things that would be kept in your file for the moment. And what about notes from meetings that you attended?
Everything in my file would go to defense counsel.
Okay. And how were your documents? No, I meant, did you keep them? Or just talking about your file management rather than what you sent to counsel?
I'm not sure I understand the question.
Would you keep in your file notes from meetings?
Yes, if I kept notes. I didn't generally keep notes. There was, it was, like I said, it was high volume. We might have discussions, but everything would be confirmed usually in an email or a report from defense counsel.
How did you keep your electronic files again before 2020? Did you have a folder system within your inbox, or was there some other repository for to keep electronic communication that you received?
If electronic communications were received on a claim, they would go in my claim file.
And
if I had a
delete?
Sorry?
And then would you delete them from your inbox?
Yes. The only times I would keep some would be potentially for future reference, for potential application to other claim files, something useful that I could use for another claim.
I have some questions now about document collection. You went through a little in terms of the adjuster doing an investigation and sending you information that they had collected, like photographs, for example. Who was responsible for document collection on a claim once a statement of claim was issued and there was defense counsel?
Once, if there was defense counsel that was retained, they took over the assembling of the documentary collection, definitely, because risks involvement, appreciating that we receive thousands of claims. We don't investigate or necessarily collect every single document that might be out there. We collect enough to be able to make a determination. When a matter goes to litigation and there's a statement of claim, now we're going through the process as per the rules of civil procedure. It goes to defense counsel. They have everything that we would have gathered, and then they would take over dealing with the client department directly, work with the city's discovery representative moving forward insofar as compiling all of the documents or reviewing all of the documents for the purposes of the affidavit of documents. So basically that torch is pushed, I guess, passed over to defense counsel, if you will, to carry on that documentary investigation.
Did you assist defense counsel with identifying relevant departments within the city for document collection purposes?
They are primarily responsible, but I am there to assist them or facilitate or provide my experience or contacts or suggestions and how to get those documents, who to contact, who I might think they might be should deal with.
Did you act as a liaison between defense counsel and city staff from whom they wanted documents?
Yes, I typically put them in touch with each other. I really was not involved. My preference was not to be a middleman, so to speak, or to be getting all those documents for defense counsel, looking at and then providing them. I put the deponent on the affidavit of documents, or the representative, directly in contact with defense counsel so that they could ask the questions and get what they needed, or make sure, I guess, because I know about affidavits of documents, Schedule A productions, that they complete the necessary investigation to be able to satisfy themselves that the affidavit of documents is as accurate as possible.
Did you have a practice of reviewing documents you received in one piece of litigation and cross-referencing it to other litigation where it might be helpful or relevant?
That wasn't my practice unless, it really stood out to me. It was not my practice to do that. Every claim is looked at on its face and individually. There are hundreds and hundreds and hundreds of them that I was dealing with. And so each claim was, unless, for example, it's something came out to me that, it popped into my mind that I think might be useful to another defense counsel. I certainly was a purveyor of trying to share information to make sure that everyone had the kind of information or undertook the same kind of consistent approach with dealing with claims. I wanted to make sure that others had the information. Yeah.
Thank you. And the inquirers received information that both external legal counsel worked on city claims, but there was also internal legal counsel who worked on claims. In what instances are external legal counsel retained versus when does something stay in-house?
For my perspective, and this comes back to the insurance notice program now. So when we are dealing with claims that had the potential or possibility of exceeding this SIR of the city, insurers would be involved in the course of the investigation. And oftentimes their preference is to have external legal counsel of their choice overseeing the defense of those claims, and to ensure that there's appropriate resources to be able to defend them. And external resources sometimes are in a better position to do that. And it's ultimately the insurer's call when files went to external counsel. Otherwise, we have an in-house legal team that would deal with the majority of the claims that went to litigation.
What are your expectations, the kind of updates that you'd receive from defense counsel, both internal and external?
My expectations are that we would first get a preliminary report from defense counsel assigned. If their review, certainly in-house, the reporting levels in-house probably weren't at the same level as external counsel. And I think it's because of sheer volume again. But certainly external counsel would provide a preliminary review of all the documents that have been compiled. It's based on risk management's file. Everything that we have, they review it, they look at it, they provide their opinion on liability and damages, what further investigation and might be required through the city's representative through the discovery process, what they also will be doing from a damages perspective. They might provide a preliminary assessment on potential exposures, and then we'll continue to report as the litigation moves on, so that there be a preliminary report, The next expectation would be at milestone events or something, raised that requires or behooved council to want to communicate a material change to their initial report. Otherwise, we'd be looking for something after discoveries are completed, a discovery report. And then thereafter, there would probably be a consideration for retaining experts and strategy moving forward, and having those would be the milestone reports that I'd be looking for.
Thank you. So you mentioned before the affidavit of documents, but just so that I have your evidence clearly, do you have any role in identifying the appropriate city staff to affirm an affidavit of documents or to participate in examinations for discovery?
No, I don't typically do that. We will go to the client group and ask who the discovery rep would be. But I'm not, and they would certainly appoint somebody, and then the defense counsel works with that deponent. But as they have those discussions, they might find, well, this person really isn't the best person to be the discovery rep. So those kinds of discussions sometimes happen thereafter. And I may be a facilitator. Again, going back, is there somebody else that's, we would prefer a person who has knowledge in this area or that one. So it's not an arbitrary, this is the person and you have to work with it. There's certainly, we want to make sure that the best representative is available to give evidence at discoveries. I gave evidence once in my in my career as a discovery rep, and I really didn't want to do it, but I did it because we had multiple departments that were involved, and it was just, it was more streamlined if I had attended and instead and eliminated many of the undertakings. And I was able to answer many more of the questions because it was across multiple departments. But that was a very unique situation. Otherwise, it's always going to be somebody in the most relevant department having regard to the allegations and the claim that would be attending.
Do you review draft affidavits of documents before they're filed?
No, I don't typically see them. I don't need to see them at all. I have received the odd one over the years, but I often say to counsel, you don't need to send these to me. It's fine to stay in your own files.
Turning now to some specific questions about the Red Hill. The inquiries received documents that as of 2008, members of council and public works staff started to receive these anecdotal complaints. So just again, I know I asked you this before about Hansen, but were you personally made aware of anecdotal complaints about slipperiness on the Red Hill?
No, going back to 2008, that's a long time ago. I couldn't say one way or another, but that would be something that traffic and design would be responsible to respond to. That I wouldn't get involved in that. Matters of safety matters, traffic controls, design of the roadway, that really falls to the experts, and they're the experts there, the engineers.
Understood. My question was really about your knowledge rather than about your responsibility. So you didn't have any sense from reports, from discussions internally with staff, from media, that there was any anecdotal complaints or concerns about the Red Hill dating back to 2008? I
couldn't remember that.
Okay. In 2013, public works staff started to conduct safety reviews and assessments on the Red Hill. The Tradewind report is one piece of the work from Public Works, and we know it came to your attention at a later time. But just going back to 2013, were you aware in the fall of 2013 that Golder Associates had been retained to review aspects of the Red Hill?
No.
Were you aware that Golder had hired Tradewin to conduct a friction test on the Red Hill?
No,
Were you aware in the fall of 2013 that CMAT was retained to conduct a safety review on the portion of the Red Hill?
no,
And there were subsequent studies conducted by CMAT in 2015, 2017, and 2018. Were you aware of these studies at the time?
no, I think it came up through council, Shillington's, who was on, I think, somewhere around 2017, 2018.
So we will come to those, certainly. But that's the source of your understanding and awareness about the public works initiatives in respect of the Red Hill.
Yes, no, Public Works did not communicate those studies to me.
Thank you. So we're going to start in 2013. There was a very heavy rainfall incident on the Red Hill, and there were a number of accidents reported. Following this incident, there were a number of emails exchanged among city staff about the accidents and about complaints about the Red Hill road surface being slippery and wet. You're not copied on those, but I'm just going to ask you some questions to understand whether you were brought into the loop by anyone who was copied. Registrar, can you go to GOL 2641, please? And can you go to image 4, please? Ms. Swaby, just so that we do a little tech test, because this is the first time we're looking at a document, can you see both the screens where Ms. Hale and I and the commissioner are?
Yes.
And you can also see the document?
Yes.
Great. I will ask the registrar to call out documents to make them a little bigger, recognizing the font might be a bit small. Registrar, can you pull out the bottom email on this email chain, please? Thank you. So Ms. Whibby, this is drawing you to time. This is September 22, 2013. And this is an email amongst staff in the operations department, those who are actually on the roadway. And it's a district supervisor reporting to his superintendent about heavy rain we had. So this is not a flooding incident. This is just a very heavy rainstorm. Okay. Recognizing it was a long time ago. Do you remember this rainstorm in September of 2013?
No.
The district supervisor, Sam Capostano, said it's very slippery. We've checked the ramps and the road, and it's very slippery. There's not much we can do. Registrar, you can close this down. So you're not copied on that email. But this email starts to make its way through both first operations and then into traffic safety staff. Registrar, can you go to image 3? And can you call up Mr. White's email on the bottom half of that page, please? So it gets sent to excuse me. It gets sent to staff who get involved in this discussion include Mr. White, who is in traffic. Do you know Mr. White?
I knew of him, yes.
And Mr. Moore.
Yes, I know they're both individuals that work in Public Works. Some of these names look familiar, yes.
And you'll see that Mr. White and registrar, perhaps just to assist, you could help with this. About 7 lines down, they're talking about this issue, Mr. White is, and he says, we will also confer with risk management regarding this matter. Yeah, thank you, registrar. You see that, Ms. Swaby?
Yes.
And you'll see that that Mr. McLennan is also copied on this email. In fact, Mr. White copies him in. Registrar, could you close this down? And if you can go to image 2, please. and call up Mr. McLennan's email. So he says, off the top of my head, I'd say that there's not a more significant claims history for slippery conditions on the Red Hill, certainly no more than any mountain cut. And then he says, we can run a location-based report on Riskmaster, and by copy to Gavin Chamberlain, I will ask you to discuss this with me. So just stopping there, I think you said earlier that location of loss was something that would go into Riskmaster. Back in 2013, were you confident that doing a location-based report on Riskmaster would actually bring up the documents that would be relevant to a particular location?
It would depend how the location was inputted. And Riskmaster wasn't a kind of software program where perhaps every location could be might be populated and you had to find it and then click on it to pick it. I'm not sure if you understand what I mean by that. Having that information predisposed in there, that wasn't there. So whatever was inputted is what you'd have to input as well in your search requirements to capture it. So I don't know what Gavin was, what type of search or what went into his search to capture the claims, but he would have had to have considered things like RHVP, Red Hill Valley Parkway, different descriptors to be able to capture all of them. So I'm not sure how comprehensive his search would have been, whether he would have tried a number of different ways. It was a very challenging, and it still remains a challenging system to deal with from that respect.
Thank you. Registrar, you can close this down. And if you can call up Mr. Moore's email. So Ms. Swaby, you've already given evidence that you don't recall any friction test, knowing about any friction tests. So Mr. Moore on September 30th of 2013 indicates to those copied, who do not include you, but do include Mr. McLennan, that we will have skid resistance testing completed on both the Red Hill and the Link. So just stopping there, were you told by anybody that this friction test was going to be completed for the purposes of, as you'll see, Mr. Moore says, this should be sufficient for any due diligence required, eliminating the ought to have knowns, as well as dealing with we think it is slippery issues?
I don't recall. I typically, my area was claims, so I didn't really get involved with a whole lot of day-to-day operations or decisions being made that weren't specific to a claim or any risk management and involvement with the day-to-day operations, if you will.
But you can see how having a skid resistance test might and findings that skid resistance is good might be useful to you in claims that the Parkway was slippery when wet.
Sure, and I would expect that eventually that would be gleaned through the litigation and or claims investigation process.
In any event, you don't remember having any discussions with anybody about Mr. Moore's commitment to do this test?
No, I don't remember.
Registrar, you can close this down. If you can go to image 1, please. And if you can pull out the bottom email. This is a short one. Mr. McLennan says, the claims history for slippery pavement is basically non-existent, only one claim, although I suspect we'll get a few from the recent incident. So I know that he has asked Mr. Chamberlain to run the claims report. Do you recall if you did any assessment of the number or type of claims on the Red Hill during this time?
No. I had a number of claims on the Red Hill. Yes. What was the question again? Sorry.
The question was, did you do any assessment of the type of claims on the Red Hill?
No.
Registrar, you can close this down. you can close this document down. And if you could call up RHV 1017, image 5, please. So this is an appendix to an affidavit that Mr. McLennan filed in the inquiry, and it has a list of claims involving the Red Hill. We were just looking at September of 2013. I'm just looking at the first 4 of those, recognizing the last doesn't come in until November 2013, but looking at that period of time, were all of those claims assigned to you when they came in?
Of the first 4, you say?
Yes.
I don't recognize the first 2. I do recognize Ghulam Mustafa and Garlash.
And just so that we don't have to come back to this later going forward, were you also assigned to the other claims that are listed on this appendix?
Eventually, they all were. I'm not sure that they were all originally.
Thank you. There's a couple more on the next page as well, if you wouldn't mind. So you can see those names.
Yeah, I don't recognize the Salonen name. I do. Gapiv was mine, yes.
So just more generally, and I think you said earlier, the Red Hill claims were generally assigned to you by you.
Yes, but there were a few that I noticed afterwards when we started putting this list together. I saw some names that I didn't recognize, and I looked back at least in 1 or 2 of them. I'm like, oh, how come I don't see that one? Oh, it came in, John assigned it and went to Kathy or another claims representative. So there was the odd one that wasn't with me.
I see. Thank you. Okay. Registrar, you can close this down. Before we turn to more RHV specific questions, in terms of you and Mr. McLennan's respective roles, how frequently did you check in with him about your files?
Not very often. Certainly, only when I thought there was something that I might think he should be aware of from a large issue potentially that might cross into what he might be working on or what he should potentially know as a manager of a potential exposure. My primary dealing is with those claims, making sure there's coverage, making sure they're dealt with properly, making sure the insurer is involved. And I wouldn't be going to him. When would I go to him? If we were potentially dealing with a loss that had an exposure that was over risk management's authority to settle a claim, and that we need to, seek approval of certain settlements. In that respect, that would be certainly a time that I would always go to him, obviously, because it has to go through him and then up through the chain of approvals. But generally speaking, I trudged ahead with the claims myself, and he was busy doing other matters that weren't so claims. And he had his own claims, but he was also dealing with all of the operational day-to-day risk management advice and questions that would be coming in. That was more his area.
In terms of rather than sort of a formal reporting to him as your boss, so leaving sort of that aspect aside, did you have regular discussions and interactions with him about the status of your cases, even just to vent or to chat as colleagues?
Well, sure. His office was right next door to me. So he would often hear me talking about claims. So yeah, we would talk from time to time about claims, very generally. Generally speaking, if there was one that came by that I wanted, it was worth a discussion to talk about on whatever level, if it was interesting or for whatever reason, it's just really just more of a casual discussions.
Turning now to back to the Red Hill. Registrar, can you bring up HAM 61930? And if you go to image 3 first, please. And if you can call out Ms. Crawford's email down to the bottom, just so it's a little bit bigger. So this is an email from Ms. Crawford to you and to Gary Kirchnoff, as well as to Mr. Shillington, with whom she worked. And she writes to Gary, we have 3 separate matters for the city of Hamilton involving accidents on the Red Hill. So just stopping there, did you give Ms. Crawford or Mr. Shillington Mr. Kirchnoff's name as a person to contact about these 3 separate matters?
Yes, I'm sure I would have given them his name as a contact. I seem to recall going back then, it was after Hart Solomon had left, and Gary, I think, was kind of put into that position. He was certainly the person I was going to start with to say, where are we going to get what we need to for defense counsel to do their jobs.
Why were you copied on this email, if you know?
Because I think Gary may or may not have been aware of Colleen and Shillington's, because they were external counsel, and public works and city staff are usually accustomed to dealing with internal legal counsel. So they're going to get a request from Colleen. They may not know who Colleen is, and she would be copying me on it so that Gary knew that this is certainly City of Hamilton's counsel, and if they had any questions or concerns about working with Colleen, they could reach out to me.
Registrar, you can close this down, and if you could go and pull out the image 1 and 2. And at the very bottom of image 1, you'll see it says, "Hi, Dan," and this is from Gary. And then Registrar, could you put at the top of image 2? So Mr. Kirchnoff said that he, my director advised me today that due to the complex nature of these claims across 3 different divisions, we should set up a meeting with Mr. Moore, Mr. Mader, and Mr. Scheinel. Registrar, you can close that down. Was that unusual to have 3 different divisions involved at the outset of a claim?
Was it unusual? No, it is not unusual to have multiple divisions involved in a claim.
And then if you could call out the second email down, the one January 15th is from Diana Sabados. Registrar. Perfect, thank you. So you suggested that you would attend this meeting on behalf of risk management along with Mr. Shillington's office. You see that?
Yes.
Was it your practice to attend meetings between defense counsel and city staff?
No, it wasn't. It wasn't, but sometimes I would offer myself to be there, especially if staff were not used to dealing with external counsel. And, really my role there is more to, again, hold hands and facilitate and, provide some direction or reassurance to staff if they had any questions about Mr. Shillington's involvement.
Registrar, could you close this down and go to OD6, page 104, please? And if you could call it 275. Tracking their process, that meeting is scheduled for February 21. We can see through emails I'm not going to take you to now. Mr. Mader can attend and sends Mr. Chris Jacobson. Do you recall attending a meeting with Mr. Moore, Mr. Scheinel, and Mr. Jacobson and Shillingtons in February of 2014?
I don't remember. It doesn't mean I wasn't there. I just don't remember.
Do you recall if there was any discussion at this meeting about friction testing or friction levels on the Red Hill?
No.
No, you don't remember either
I
way?
don't remember. I don't remember. Sorry, I don't remember. No.
That's all right.
If I was there, it was really to coordinate getting the information to Shillingtons that they need insofar as disclosure for the purposes of the productions and the affidavit of documents. And if it turned out that we had to go to different individual employees to gather all this information, that would have been the purpose of that meeting.
Registrar, you can close this down. If you can call up HAM 649, pardon me, let me try that again. HAM 64294. And if you can call out all the text just to make it a little bit bigger. Thank you. So Ms. Swaby, you spoke earlier about retaining independent adjusters to investigate. Is Mr. Tollis, to whom this email is sent, is he one of those independent adjusters?
Yes.
And you are referencing the subject line as Hansen, and it says this is an attached statement of claim. Hansen is a case that was assigned to you, is that right?
Yes. Well, it looks like a statement of claim came in and was either I received it personally or John would have received it and forwarded it to me.
And in terms of who actually had assignment within risk management for it, you were the assigned file handler?
Yes.
And we know that there is a second accident that is related to the accident, Hansen, the Burnett matter. Were you also assigned to that one?
I believe so, yes.
And Mr. Tollis as well?
Yes, I would imagine so, yes.
In the third paragraph, it says, so you say, in the second paragraph, you say, I want a police report and a police file. And then you say, I can say that unless there is some evidence of a slippery substance on the roadway, which I seriously doubt, we will be denying the claim and looking to the plaintiff for the city's costs. So just stopping there, can you explain why you referenced the potential of a slippery substance?
We have had a few claims over the course of the years involving either a spill on a roadway or incorrect application of a material that we use for winter maintenance conditions. An indication that there was some foreign material on the roadway. And so that's where that reference came from. If I recall correctly, this was an issue of tire blowing. And I would have really honed in on that fact when I was assigning this claim.
So there wasn't anything particular in your mind in 2017 that you had knowledge about in terms of slippery substances or slipperiness on the roadway?
No, I was just thinking of my prior claims experience dealing with a couple of claims involving either spills from vehicles that are driving along, mechanical dysfunction, previous accident, and or inappropriate application of a treatment on the roadway for the purposes of a winter maintenance. So that would have been what was in my mind at the time, my previous claims experience.
Thank you.
Ms. Lawrence, a matter has come up that I have to deal with very quickly. Could we take a 5-minute break at this point?
It is 10:45. It's 15 minutes before the time we would normally take our 11 o'clock break. I'm in your hands, Commissioner, if you'd like to take 5 minutes or if you'd like to take a break a little earlier than we would and have.
And why don't we take a break a little bit earlier and we'll return at 11 o'clock. Okay.
Commissioner, may I proceed?
Yes, please do.
Thank you. I note that the document that we were looking at just before the break is not in evidence yet, and I'd like to mark it as the next exhibit. It's HAM 64294.
Noted, Council. Thank you. It's Exhibit 180.
Okay.
Registrar, can you bring up HAM 52704, please? Could you pull up the next page as well? Miss Swaby, this is a 6-page Spectator article. At least it's 6 pages in this electronic form, so it's a lengthy article. Do you remember reviewing this article when it was published in July of 2017?
When it was published, likely not. I think it was forwarded to me by Shillington's potentially, as a matter of FYI, if I recall correctly.
That it is correct. Registrar, can you take this down for the moment and bring up HAM 61962? Ms. Swaby, you'll see this is July 15, so that's the day that it's published. There's a Google alert, and then on the bottom that goes to Ms. Crawford, and then Ms. Crawford on the 17th forwards it to you and to Mr. Thompson and Mr. Shillington at her office. And then you respond, hi, Colleen, the site is blocked. Can you confirm which file? Is that what you were thinking of?
Yes, I know that Colleen would often send me some of the media coverage, or attempt to send me some of the media coverage on various files.
Registrar, could you call up now HAM 61963? And Ms. Crawford then sends you a link rather than the Google the Google alert link. She sends a separate link to the spec website, and you said yes, it was blocked. It might be because I'm going through your typos, are not permitted to blog or write emails to the spec. So just stop right there when you, just so that I understand that the internal processes, if you click on that spec article in this form that she said, now you'd be able to access it, or would you not?
No, I would have tried to, and I still couldn't get at it. So it could have been 2 reasons. And one is, like at one point there was an account that we had been provided through another department that we might be able to access it without a subscription, but I didn't have a Spectator subscription. The other part of it, sometimes IT blocks certain websites as not being something that they allow, as it might be questionable from a virus standpoint or something along those lines. So sometimes when I try to search things, I can't access them through the internet.
Mr. McLennan also forwards it to you, and we'll get there in a moment. But just before we do, for Ms. Crawford, I think you said it was not uncommon for her to send you news clippings on relevant cases.
Yes.
And did you review the article sometime around July?
I couldn't say definitively when I reviewed the article.
Okay. Before we move on, both the last 2 documents from the emails with Ms. Crawford are not in evidence and need to be marked. So the first one would be HAM 61962, which by my count would be Exhibit 181. And then this document, HAM 61963, which would be 182.
Great, thank you, counsel. Noted.
Registrar, you can close this down if you can bring up HAM 61. Sorry, let me just make sure that I have the right. HAM 26216. And if you can call that out just to make it a little bigger. Thank you. So this is the same day, and this is the emails between you and Mr. McLennan. And you'll see he forwards it to you from the hamiltonnews.com service. Were you able to access the hamiltonnews.com link?
I would say no from this only because it says I couldn't access because IT blocked it. Not all bad. I'm not sure. Apparently there's an email to a journalist on one of my claims saying they are not pursuing. I would have probably been providing that, again, going back to my claims experience and talking about previous claims. Somewhere I got that information, but I can't recall now where it came from.
Do you recall if you spoke to Ms. Crawford who conveyed that to you?
It could be. She would have been my source of giving me some information because I didn't proactively review media coverage.
Did you speak to Mr. McLennan about the article that he forwarded to you?
I likely had some conversation with him about them, a candid conversation about media coverage.
In that conversation, did he explain what he meant by not all bad?
No, I can't recall any specific conversation about it and what he would mean by not all bad. I'd have to look at that article again to form an opinion by what he meant by that.
So I presume this is not the first or only instance where you receive a media report that's related to your claims. You said Ms. Crawford sent them to you. Typically, what were your practices upon receipt of an article like this in terms of file management?
What would I do with them? It might go in my file as a matter of an FYI as some information that came in, which would ultimately, if it was pre-litigation, it would end up being shared with defense counsel assigned if it ended up going to litigation. Sometimes when I get a notice of a claim in and it doesn't have very much information, I might try going on the internet and seeing if I could find some information about an accident on a particular roadway. That might be the only time I do a proactive search looking for some information just to try and assist our external adjuster insofar as identifying perhaps a specific location in order to conduct a field investigation.
Here, where defense counsel has already been assigned, would you review media articles to assist defense counsel?
In this case, defense counsel was giving it to me, so it would be more of an FOI to me as opposed to me doing something for them, I suppose. Does that answer the question?
It does, but of course you have more knowledge about the way the city works
Right.
internally. So there may be nuances within city departments or information that would be in your knowledge, but not necessarily defense counsel. And so would you review it for that purpose?
No, and really to dovetail that point, I'm really almost in the same position as defense counsel is. Whatever information they have is the last information that I have. And so if they're actively involved in it, now they have, there might be information that's gleaned from that article, and that would certainly behoove them to review that with the contact in the client group to get whatever further information is needed for the purposes of defending that particular claim or any of the claims that they were handling.
In this case, this is involving the Red Hill. So it's not just Shillington's who has cases or could have cases about the Red Hill. So you are a repository for information for others. Would you agree with that?
Yes, but in my mind, I thought I had all of the Red Hill claims. I didn't realize that there were some other ones that were out there. Well, I suppose there were some with in-house counsel, but I don't recall them being as active as the Shillington's litigation, which would have been at the top of my list, having regard to them being reported to the insurers, and we're working with the insurers and staying on top of them. So I was very certainly reactive to, as a matter of priority, to the communications as people are reporting, as defense counsel are reporting to us. Those are the ones that are at the top of my list.
Registrar, could you pull out HAM 52704, image 2, please? So this is the second page of the article. That first page has the picture, and then this is where the text starts. Registrar, can you pull out the first 5 paragraphs, please? Ms. Waby, in the second paragraph, there's a reference to City of Hamilton statistics that show many crashes happen in the curvy parts of the road. Were those statistics, generally City of Hamilton statistics about crashes, provided to risk management?
Not to me. They weren't. They might be eventually in the context of a specific claim, and as we investigate each claim, we would ask for such things as a collision history as part of the investigation for each individual claim. But as an aside, if there was no claim, I wasn't involved in monitoring ongoing collision histories on a general level.
The fourth paragraph says, rumor and speculation about the Red Hill being slippery have plagued the Parkway since it opened in 2007. And you've already given evidence that you didn't have any sense of anecdotal complaints. Did you have any, did you know about the rumors and speculation that are referenced in this Spectator report?
No, not. It would be these very articles that bring that to my attention as something that certainly the Spectator has that information. They probably have more than me at that point.
The last paragraph in this call out, the 5th paragraph of this image, the city has done limited friction testing on the road, but refuses to make the results public, saying only they were ultimately inconclusive. When did, perhaps I'll just go circle back. Can you pinpoint when you did read this article?
No, I don't think I can remember when exactly I did it. It'd be unlikely I read it when it was published. It would have been sometime after it was brought to my attention.
When you read it, did you turn your mind to the fact that friction testing might be a responsive document in the lawsuits that you were overseeing?
Not really, no. That would be the responsibility of defense counsel. And they would be looking at as in the context of each individual claim.
Registrar, could you close this down? and go to image 4. Can you go to the next image, please? Ms. Swaby, this is quite a long article. I'm not going through all of it.
Okay.
Registrar, could you call out the bottom half of this page, please? Thank you. So the third paragraph down, it says the 2015 engineering report on the Red Hill study crashes on the road between 2008 and 2015. By this time, so this is July 2017 when this is published, had you seen the 2015 SEMA report, which I believe is what's being referenced here?
No, I don't believe so.
That same paragraph goes on to say, so there's median related collisions and there's more than half of these crashes happened when the road was wet. As of July 2017, do you recall discussing with anyone the frequency of wet weather accidents on the Red Hill?
No.
Registrar, you can close this call out. So you told us earlier that your practice was to print out relevant correspondence and file them in a particular file. Did you do that with this article?
I'm not completely sure that I was able to print it off based on looking at this. I'd have to look at my file. But certainly, Shillington's would have had it at that point. Shillington's is reporting to myself and to the insurer. And I gather from the communications happened that thereafter, Shillington's was actively looking for some more documents from our client group, likely to certainly deal with some of the information that's been put forth in this article.
You said also that sometimes you would file something within your emails for reference if you thought it might be useful later. Was this a document or the article? Is this a document that you did that with?
No, articles are not evidence to me. They are reporting, and I don't put a lot of weight on newspaper articles.
Registrar, could you bring up HAM 64106, please? And could you call it, go to image 3 first, please? Let's try image 2. Thank you. Registrar, can you call out Ms. Lazo's email at the bottom? Oh, actually, there's just some weird spacing on this. Registrar, can you close that down? Can you go to image 5, please? Okay, it was image 4. All right. That's where I wanted to be. Thank you, Registrar. That wasn't coming up before for me. Can you call out Ms. Swaby's email there, please? You send an email to Ms. Lazo attaching a statement of claim in Burnett, which we already talked about related to the Henson matter. And it says Adam's investigation is continuing. And it says, you say, please deliver a defense based on the same principles. Just stopping there, Ms. Lazo, she's a solicitor within the city's legal services division. Is that right?
Yes, yes.
And she, at the time, was the defense counsel assigned to the Hanson and Burnett matters.
Yes, I think so.
Was there a reason that the Hanson and Burnett litigation stayed in-house, where some other Red Hill files were assigned externally?
If it came to me, it certainly met the criteria for reporting to the insurer, such that Shillington's was involved, those large ones. I certainly was of the preference that Shillington's handle all of them, if I could get them to, because that way they would be aware and deal with them all consistently and be able to make sure they had all of the information on all of them. This particular one stayed in-house. Donna Lazal wanted to keep it in-house, and it may or may not have at that time, I may not have had enough information yet. I'm not quite sure. It met the criteria to remain in-house. And so that may have been the reason why this one stayed in-house at that particular time. My comments here as well, again, come from a claims experience perspective.
Registrar, you can close this call out. And can you go to image 2, please? So I called out just a moment ago, but we didn't actually go through the bottom email from Ms. Lazo, which you're not copied on. And it's just dealing with the logistics of defense.
Yes.
Registrar, you can close that down. And if you can call out Mr. Sabo's email. So Mr. Sabo, again, on an email you're not copied on, says, this may be somewhat related to recent articles in The Spectator questioning the choice of paving material. The story has a staffer saying they wouldn't release a study done on the surface to the effect or everyone would sue us. I expect the study will be a relevant record. You can close that down. And if you can go to image 1, please. So you do get brought back into this after that exchange. Registrar, could you bring in the bottom email? And you say, are you aware of this study? Do you know where Donna, and she says, do you know where Donna and I can obtain a copy? Registrar, you can close this down. And then at the top, if you can call out Ms. Swaby's email in response. You say, I failed to see how the type of material used on the roadway, used on the road caused the tire to blow. Thousands of vehicles traverse this road every day. In the event I'm not aware of any study, I would try Marco Odie. Registrar, you can close that down. So at the time that you're having this email exchange, which is August 10th of 2017, it's about 3 weeks after The Spectator has released that article. Do you make the connection between Mr. Sabo's email and his reference to The Spectator and the article that you were sent from Ms. Crawford and Mr. McLennan?
Have I made the connection? Well, to me, it would seem that Ron Sabo is certainly providing that information on the same wavelength that John McLennan has and Colleen Crawford has, in the sense that there is an article out there that suggests that the pavement and surface material might be an issue. Again, so I'm hearing it from 3 different sources. We all know it now. The next step is go to Marco Odie and find out that information.
Why would you go to Mr. Odie instead of Mr. Moore, who's referenced in the article?
Marco Odie was our contact for all of the Red Hill litigation, our primary discovery deponent, and as I understood it, he reported to Gary Moore.
So is your response here consistent with your practice where defense counsel asks about a document you don't have or you aren't aware of? That is, here you direct them to a staff member?
Absolutely. It always goes to the deponent or the representative of the city as the litigation moves forward. I have what I have in the course of our risk management investigation. And then when counsel takes over and we start pulling away the layers, it's quite normal to have considerable more documents produced once defense counsel is assigned.
And you didn't take any other steps to provide information to Ms. Morrison or Ms. Lizzo?
The expectation is defense counsel and their team deal directly. I don't normally get involved with further investigation requests once defense counsel is involved, unless they're asking for an external person to be retained to do some sort of field investigation.
Registrar, can you bring up OD7, page 190 and 191, please? Thank you. And can you call out 560 to 562? So I'm just jumping back in time a little to July 20th. Ms. Crawford emailed Mr. Ferguson under the subject line Melo Lee Barlow. And just stopping there, when she sent you the link to the Hamilton Spectator, she doesn't reference the particular file name and you say which file. Was it clear from your back and forth that Ms. Crawford was talking about the Melo Lee Barlow file when she sent you that Spectator link?
No, because they had claims on the link and on Red Hill that they were defending for the city.
So Ms. Crawford emails Mr. Ferguson, that's David Ferguson in traffic, and says, we represent the city. We'd like to arrange a telephone conference review to review the roads, the recent friction studies completed by the city and the proposed road work. Why was Ms. Crawford reaching out to Mr. Ferguson? Did they have some previous interaction that would lead to her viewing him to be the appropriate person?
I'm not sure where she got Mr. Ferguson's contact information from, whether it was through previous emails that have been exchanged that she was already had in her possession, or whether I know that she was making inquiries, trying to get information from different people, recognizing that we had 2 or 3 different sections that potentially could be responding. So I'm not sure why she chose Mr. Ferguson.
Okay. Registrar, you can close this down if you can call out 567. Oh, actually, sorry, before you close that out, just to orient you, Ms. Swaby, Mr. Ferguson says, when it comes to friction testing, Gary Moore should be approached, as I've not seen the results, nor have I been involved in the process. So sorry, just to close that loop.
Okay.
Registrar, you can close this down if you can call out 567. So this is our overview document, which is a summary of emails. I'm not going to take you to the underlying email, but you'll see here Ms. Cameron, who is Mr. Moore's assistant, and Ms. Crawford exchanged emails on August 11th to set an appointment for Mr. Moore and Ms. Crawford to speak. You're not copied on those emails. Did you attend the conference call between Mr. Moore and Shillington's?
I don't believe so. I certainly don't have a recollection of that.
Were you otherwise aware that Ms. Crawford was going to have a call with Mr. Moore?
I don't know specifically that there was going to be a call, but I know that Colleen was actively working on trying to get all of the documents assembled. And I certainly suggested to her to go ahead and reach out to staff as she felt the need to get what she needed.
My question was more about your knowledge at the time, and maybe I'll ask it in this way. You're not copied on that. Was that consistent with your practices with Shillington's about how involved you were when their staff were dealing with city staff?
Yeah, I did not need to be copied on every communication. There was no expectation that that happened.
And what about updates? If Shillington's was going to speak to a city staff member, would they let you know that?
No, not necessarily.
And would they let you know that if such a call had happened after it happened?
Eventually it would happen in a reporting letter when they're summarizing their further investigation or further assembling the documents and what they glean from it. Eventually I would. They're more likely to reach out to me when they're not getting the cooperation from the client department and not getting what they need and they need me to help. That's more likely when I would expect them to call me.
I see. Registrar, can you close this down and go to the next page, 192? And if you can call out the top half of that page before heading FF. On August 15th, which is the day of their call, Mr. Mark emailed Ms. Crawford under the subject line Red Hill friction report. He didn't copy you on that email or anyone besides Ms. Crawford. And he says, as requested, the testing was done in late 2013. I received it in early 2014, and he attached a copy of the trade room report to that email. We know that you later received a forward of this email and the attached Tradewind report from Ms. Crawford in 2018, and that you also received a reporting letter from Shillington's in which it's mentioned. Leaving those aside and casting your mind back to mid-August 2017, did anyone at Shillington's advise you that they had received the Tradewind report from Mr. Moore in August?
I can't remember. I'd have to look for an email confirming that.
Well, we're several years into this inquiry. Have you not already gone and looked?
No, they would be in the, I did not review all my Red Hill or my claims files, if that's what you're asking.
Ms. Waby, this is a critical point. Casting your mind back to 2017, can you please really search your memory? I think we've received all of your documents. We don't have a document that suggests that Ms. Shillington advised you. Do you recall either way if Mr. Shillington or anyone at his staff advised you that they'd received a trade room report from Mr. Moore in August of 2017?
I can't remember. It's 7 years ago.
Okay. If you had received such an update, would you have made a note of it?
It would be in my file. It would be the email with it attached and it printed off. It would be in the file.
Leaving aside a document exchange or an email exchange, would Ms. Crawford, in her usual practice, knowing her as you do, have sent you, have called you or left you a voicemail about this? Or would that be over and above her usual practice with you?
It's probably, they don't report everything that they do on their files. I get milestone reporting reports. She may have called me, she may have not, and
Okay.
either would have been completely acceptable.
Registrar, can you go to HAM 64111? And can you call out from Dear Mr. Thompson to yours very truly? So this is an email that you're not copied on, and it's an email to Mr. Thompson at Shillington's from counsel in the reference to the cases Maria Lee and Vanderberg, which am I correct, is part of the Milo Lee Barlow litigation? That's the Lee.
Yes, I believe there was 2 or 3 statement of claims issued as arising from that motor vehicle accident.
And counsel asks, will you please immediately provide our office with your client's affidavit documents and copies of all Schedule A productions, including copies of friction testing conducted by the city of Hamilton. So this goes to Mr. Thompson. It doesn't go to you. Were you aware that plaintiff's counsel was making these requests for friction testing? And sorry, just registrar, if you can close this down for a moment. You'll see this is August 11th. Were you aware then that or in and about August of 2017 that plaintiff's counsel was making this request for friction testing results in particular?
I know that plaintiff's counsel were asking for friction testing specifically, and Shillington's office was working on getting that information.
Okay, and how did you know that plaintiff's counsel was asking for friction testing and specifically?
I think it was as a result of the Shillington's inquiries about friction testing to the client group.
You weren't copied on those. How did you know?
How did I know? Isn't there, I seem to recall there was a previous email where they're asking about friction testing. It's raised in the article. They're looking for it. That's my best recollection, that it did come up, that people were asking about the friction testing in the course of the litigation. Whether it was before or after this, I'm not sure. I'm not good with dates and timings.
So I know it's quite difficult to separate out what you knew at the time with what you know now, and you've prepared for today and you've gone through interviews and you've looked at documents, and it's very hard to not pollinate your memory with what you know now. But going back in time, do you recall that anyone from Shillington specifically advised you that the plaintiff's counsel was looking for these friction testing reports?
I can't recall without looking at a report saying plaintiff's counsel is asking for it. I wouldn't be able to recall that now. I do not have an independent recollection. I rely heavily on the reporting letters.
Okay. There was a reporting letter that came in January of 2018. So that's several months after what we're looking at now in August of 2017.
Okay.
And so you don't remember either way whether Shillington's advised you between August of 2017 and January of 2018 when they sent the reporting letter about the specific request for friction testing.
No.
Okay. Registrar, could you make this a document the next exhibit? It's HAM 64111 and it's exhibit 183 by my count.
Noted, counsel. Thank you.
Thank you. Let's go to that reporting letter in January of 2018. It's HAM 64357. So the first page, at least of the document the inquiry has, is not very helpful, but just looking through, it's sent to you January 31, 2018, and it's referenced to Mello, Barlow, and Lee, seeing the subject line.
Yes.
Go on to the next page, please. Ms. Swaby, have you had a chance to review this document recently?
Yes.
Okay, so I'm not going to take you through all of it. I do have some questions about the substance of it, but before we get into it, I'd like to understand what your expectations were of defense counsel. What information did you expect defense counsel to include in a reporting letter to you? And perhaps just to direct you, or maybe I'll ask you a few different things and then you can speak to it, just so that we can tailor your response to the questions I'm interested in. Did you expect defense counsel to provide you about updates with meetings with staff?
Yes, not every detail, but what's material and relevant. Yes.
What about the status of document collection?
if there were still matters outstanding that they were looking to get, they would say that we're still working on getting those documents and that there might be a further opinion that happens after that, after they review those documents.
What about identifying gaps in document collection or knowledge at this of defense counsel?
What do you mean by gaps? Meaning that something exists and it's not there, or not being able to answer some of the questions because there aren't documents?
Both. Would you expect updates about both of those things?
Eventually, once the investigation is complete and all the inquiries have been exhausted and they determine, yes, there is more or there isn't any more, and this is it, and this is the assessment we have now based on a complete review, yes, eventually it would come.
And would you expect an update on the status of litigation? You know, where they were in the process of whether pleadings had closed, whether they had, you know, how they were doing in their affidavit of documents, if there was examinations for discovery scheduled, that sort of thing?
Yes.
And you told us earlier that your practice was to print documents and put them in your physical file. Reporting letters would be included in that practice?
Yes, I would print off the communications from counsel once they took over.
Was it your practice to review reporting letters upon receipt?
Eventually, not upon receipt. I had hundreds of claims, and so I may look at them. I would try to look at them as soon as I can to make sure, skim through it quickly to see what they need from me. But if it was just moving forward, status quo, nothing particular, no real change, just moving ahead, it might be shelved and looked at a little bit later, because my primary purpose is to look for a material change in opinion. I got to worry about reserves, making sure reserves are being increased or decreased appropriately. Any requests of me for assistance where they're finding they're having difficulty getting information from the client department and looking for information that way, I would assist with that. And yeah, anything specific to me that they needed my immediate attention to help with, that would be my priority right away. But it wasn't uncommon for me for a report to sit for a few months before I looked at it.
Do you have a specific recollection of reviewing this particular reporting letter?
I don't have a specific recollection of reviewing it.
Excuse me.
But I assume I would have at some point.
Do you know when you would have?
No, not offhand.
Image 2, the image we're on right now. Registrar, could you pull out City of Hamilton records and the content that's under that heading up to pre-accident concerns? So this contains a bit of a summary of the information that follows. And Shillington says it's difficult to separate the pre-accident and post-accident complaints and traffic tasks pertaining to the link. So just stopping there, to your recollection that Mellow, Lee, and Barlow matters, they involved accidents on the link, not the Red Hill, is that right?
Yes.
Shillington says, as many of the issues in the studies were over a lengthy period of time, which overlaps with the collision. Traffic engineering reports received post-accident addressed several traffic issues that have arisen in the years leading up to the 2014 collision. To further complicate matters, certain engineering studies commissioned prior to the accident were never submitted to council due to deficiencies of the calculations. Overall, the results of the post-accident traffic engineering reports don't raise concerns regarding the design or operation of the link. Inter-office emails and buried reports, however, do raise issues that have to be addressed in order to successfully defend these actions. So stopping there, and then we're going to go to what I think is a further reference to to the complicating matters. Registrar, can you close this down and go to image 5, please? And if you can call out the first third of that under friction testing survey summary report. Shillington's references they've been provided with a copy of the friction testing survey summary report, and they reference that Gary Moore advised that the city commissioned the report as it was considering repaving operations. So just stopping there, is it unusual that in this case there's a reference to Mr. Moore, but it's not very clear whether Shillington's has spoken to Mr. Moore or if he's the one who provided the friction testing survey? Is this level of detail consistent with your expectations for reporting letters?
Yes.
The Shillington's reporting letter goes on to say, testing confirmed that friction values for the link were superior to the Red Hill, and it references the manufacturer used and that there are no directly applicable reference standards or guidelines to compare to in Canada or the US. And then it says, in conclusion, all areas of the link measured had friction values comparable to or above the relevant UK investigatory level 2, consistent values across lane positions, which indicate generally uniform pavement structure, texture, and composition. We are advised that the friction report did not go to council, spelled as if like legal counsel. And the other one earlier is spelled as council, like city council. When you read this, did you understand that Shillington's was raising a concern that this report had not been provided to the Public Works Committee or to City Council?
No, I didn't glean that from reading this report. It's a report about the pavement. It's about, we know the accident happened on the link. He has the friction testing. It's saying that it is that there is, what did he say here? They're considering repaving, testing firm friction levels, values for the link were superior to the Red Hill, that there's no standard. The link had friction values comparable to or above a UK standard. That doesn't cause concern to me. And insofar as the reference to going to City Council, I really wouldn't turn my mind to that, because that typically is not something that would affect the legal exposure of a claim. Whether or not something went to council, that might be an ancillary or a subordinate fact. If that was an issue, whether or not something went to council, that typically wasn't something that was relevant to assessing legal exposure.
Registrar, can you close this and go back to image 2, please? And if you can call it the same call as before under City of Hamilton records. So Shillington says specifically in the 3rd paragraph, interoffice emails and buried reports, however, do raise issues that will have to be addressed in order to successfully defend these actions. I infer from that there actually that there could be some impact on liability and the defense of this claim. Is that how you read that as well?
No, and I don't know. Well, I think there's an expectation that you have to explain if when city staff choose to take a certain course in their responsibilities and their work, if there's something out there and it wasn't addressed or dealt with, they have to be prepared to explain it, and that will fall to them. So I'm not sure about the reference to the word buried. I don't know that I would classify it that way, but I really have no knowledge about when Public Works decides what needs to go or be reported to City Council or not. I've never historically been involved in that process or understand how they operationally work and decide when things go to council, city council or not.
Buried reports is really, it's a term that might leap off the page as you're reading it. Did you take any steps to confirm with Shillingtons what they meant by?
No, I don't know that I would agree with it. It jumps off the page, obviously, because it suggests some kind of nefarious activity, but I don't know that I would necessarily agree with that.
I'm not asking if you would agree with it. I'm not asking if anything about the characterization of that. I'm saying when you saw that phrase, which it leaps off the page, did you go back to Shillington and say, what are you talking about buried reports? Which reports? What do you mean?
No, I wouldn't say that. A lot of times there are documents that are out there that if you don't specifically ask a client group for it, they aren't necessarily going to pick up that it's relevant or not, or that it should be produced.
Do you think that Shillingtons would have called something that city staff might not have realized was important, a buried report?
Do you think they would? I don't know what was going through. I don't know why he chose the reference to buried. If he had given me more of an explanation in here about why he calls it buried, then I'd be able to respond to that better.
And you didn't ask for more clarification about what he meant by that?
Well, it is what it is. We were going to deal with that as it moves forward in the course of this litigation. That's why he's saying he's going to have to address it to successfully defend these actions. I would expect that there's going to be a further explanation that comes out about that.
You didn't ask him in respect of this letter for clarification about what he meant by that phrase, buried reports?
Well, I would assume that he's going to be writing me further about it.
It is a yes or no question. Did you ask for more clarification about what Mr. Thompson, who's the author, what he meant by buried reports?
Did I ask him? No, I didn't ask him, not at that time, but there would be an expectation at some point that we deal with that issue.
Thank you. We looked before at emails from Mr. Sabot and Ms. Morrison from August of 2017, where they're referencing information about studies on the Red Hill and the pavement surface that was used. Did you make the connection between the studies referenced in this Shillington's letter and the summary, and particularly the summary of the Tradewind report on image 5 that we were just looking at, and the studies that legal service staff had inquired about?
So again, reference that Cheryl Morrison email. When was the date of that?
It was August of 2017, so about 6 months before you received this reporting letter.
And so the question is?
Did you make the connection between that email exchange you had with Ms. Morrison and referencing Mr. Sabot's information about pavement surface to the information that is set out in this reporting letter?
No, likely not, because I would have been having my Link and Barlow hat on, if you will, the Mellow Lee matter. I'm thinking in the context of the Link and not that context.
The letter, this reporting letter is addressed only to you. To your knowledge, did anyone else at the city receive a copy of this letter?
The letter was only addressed to me, but it would have been sent to the city's insurer as well. It wouldn't have been sent to anyone else at the city.
Did you provide a copy of this letter to anyone else at the city when you received it?
No.
Registrar, you can close the call out. Was there anything in this letter that you felt needed to be escalated to a superior?
No. We're in the middle of active litigation. It typically does not get escalated until we are at that point where we identify a real exposure. And we're not there yet necessarily.
Registrar, you can close this down, and can you go to HAN 64296, please? And can you call out at the from the first half of this top half of this document? Yeah, that's perfect. Thank you. So this is just a little bit before in time. So we were just looking at the reporting letter that is January 31, 2018. This is about a month before December 22nd, 2017, just before the December holiday period. And you email Adam Tallis about the Hansen case. And you say this claim has morphed into a large loss. We can't leave any stone unturned. So far we have traffic records. There's much more to do. Please review with John the investigations in Mustafa and Galrish. Who is John there?
John Kirschenblatt, it would be John Kirschenblatt, and he was an adjuster, a senior adjuster, if you can call him that, at, I guess it would have been Cunningham Lindsay at the time, who had familiarity and experience in dealing with some of our large loss Red Hill claims adjusting.
Thank you. So you say we need to interview witnesses and we need to likely retain experts, review black box information if available, roads patrol, et cetera, full workup. And then you say Donna Lazo is handling this file. It is her first on the Red Hill involving a large loss. And then you say she'll be attending my office to review all of Shillington's previous reports to make sure we do all that can be done to fully defend these actions. I will be in touch in the new year to set up a meeting with her, and I will include you in the invite. Is it your general practice to have in-house counsel review reports from external counsel, the way that you're suggesting Ms. Lazo does here?
Well, if there were unique circumstances such as this, when we have external counsel handling the bulk of them and now having internal counsel handling it, we'll call them one-offs, the odd one that's there, I would invite them to reach out to external counsel. And also, you know, we do have we've already have defense files with Shillington's doing quite a bit of the work and the legwork on some of these previous files. And I would invite Donna for sure to have a look to make sure that she sees or has access or can turn her mind to a lot of the issues that have already been addressed or identified by Shillington's. It's an efficient use and can expedite some issues and some matters. And I'm always trying to facilitate the sharing of information so that we take a consistent approach to all of the litigation files.
Did Ms. Lazo come to your office to review Shillington's reports as you suggested that she would here in this email to Mr. Tallis?
At some point, I know that I had made arrangements to pull some of these boxes and have them out and left them there for Donna to review at her leisure when she could.
Do you recall knowing whether she actually did come and review those boxes?
I believe she did go through them at some point. I'm just not sure when.
Can you nail it down to whether it was in the first month coming back after the December holidays?
It likely wasn't. There's the shutdown. It would have been a really busy time. Then coming back, there's always busy coming back. If the files were in storage, it would have taken some time. I would have had to ask staff to pull them, have them there. So, you know, it wouldn't be outside the realm if it was a few months before she reviewed them.
Okay. And would you ensure that all of the files were as up to date as possible while they were sort of sitting there waiting for her to review?
If Ghulam Mustafa were closed and put away, I would go through all my emails and make sure if there's anything on there to get them printed off and make sure it's in the file. I go through that process before things get closed and sent away.
Just stopping there, do you recall which files you pulled for Ms. Lazo?
No, I don't recall offhand which files I pulled. I'm assuming it was Mustafa and Garlash, because they would have been claims that really were advancing in the litigation and had been and gone quite a bit of a distance, I believe. So there
Okay.
would be more there.
What about Gapiv?
That's possible. Gapiv could have been in there.
For the Melody Barlow, would they have been, would you have pulled those ones as well?
Likely not, because it was on the link.
We know that you received Shillington's letter, the one we were just looking at in January of late January of 2018. At any point after you received this letter, did you provide a copy to Ms. Lazo?
I don't think so.
Why not?
For the same reason as my previous answer, that it was a link file.
Registrar, could you close this down and go to OD9A, page 13? And can you call out paragraphs 18 and 19, please? So we've jumped forward to May of 2018. Ms. Crawford forwarded an email she received from Gary Moore, the one that we referenced before. I took you to the OD references. And this time she copies you in, and the copy of the Tradewin report that Mr. Moore had provided to Ms. Crawford is attached to that email. In fact, just so that you can see that, because I'm not sure if I've well explained it, Registrar, can you leave this up, but can you also bring up HAM 53107? You can close the call up for the moment. So you'll see Ms. Swaby at the bottom of this email chain on the right. There's the email from Mr. Moore to Ms. Crawford on August 15, 2017, where he says, as requested, the testing was done. And that one has an attachment when we went back and looked, that one definitely has an attachment of the Tradewin report. And then you'll see Ms. Crawford is forwarding that email along with the attachment and copying you in on a subsequent email to Mr. Moore. All right, I'm going to close that down. I just wanted you to see that as an email in sort of the native form, but let's go back to the OD. And if, again, Registrar, if you can call out paragraph 18 and 19, please. So Ms. Crawford says, good afternoon, Gary. You may recall speaking to Mr. Shillington and myself last August. We're in the process of preparing the city's affidavit of documents in respect of a litigation matter involving a median crossover on the link. Plaintiff's counsel has specifically asked about friction testing. We will need to produce a copy of this report in the city's AOD. And then she wants to confirm it's been presented to council. So a few sort of questions of clarification before we get into the substance, where it says a litigation matter involving a median crossover on the link. From that information, were you able to identify what piece of litigation Ms. Crawford was preparing the affidavit of documents for?
It was likely the Mello matter. I believe that file was theirs. I don't think they had any other files on the link.
Okay. You said before that at some point you came to learn that plaintiff's counsel specifically asked about friction testing. And at the time I was referring you to the letter from plaintiff's counsel asking about that, which is from August of 2017. Here, Ms. Crawford actually says plaintiff's counsel has specifically asked about friction testing.
Okay.
Can you, with that information and seeing that this is from May of 2018, Can you assist in when you first learned that plaintiff's counsel was specifically asking about friction testing? Was it here or was it some point earlier?
It was likely here.
Don't remember either way if there was some
No.
prior communication?
I would rely heavily on the documents.
By which you mean you don't remember either way?
No, I don't. I have difficulty on a lot of my claims. I can't imagine that I have an independent recollection about many of my claims just by the sheer volume. It would have to be something really crazy for me to remember.
Okay. So Ms. Crawford is asking here, or is advising Mr. Moore and copying you that the Tradewin report will likely need to be produced as part of the city's affidavit of documents. So she copies you in on this. Based on your practices and working with Ms. Crawford, do you know why she would have copied you in at this stage, having not copied you in before?
No, I'm not sure why she copied me. Perhaps because it had been an issue that had been raised prior back in, was it 2017? Was I?
Yep.
I was in on that. So maybe she's copying me in on it again because it's the same issue.
Well, here it seems like a reference specifically to the affidavit of documents and that and confirmation about whether the issue's been presented to council. And Mr. Moore does confirm it's not been presented to council. He copies you in that email as well. In the usual course, would Ms. Crawford update you on a document that that may or may not go into an affidavit of documents if they had some concern about sensitivity with that document?
No, not necessarily. There was no hard and fast rule either way.
Based on your practices, what would you have done with these emails and the attachment, the Tradewin report upon receipt in terms of your file management, paper management practices?
They would be printed and put in the hard copy of the file.
And what about electronically? Is this a document that you would have kept electronically?
The only time I typically kept matters electronically were when they were really difficult to print off, too large, and they were actually better to be just reviewed in their electronic form, in which case I would have attached it to Riskmaster. Not very often.
Okay. And sorry, just going back to an answer that you just gave, just so that I can get some clarity on it. When I asked with Ms. Crawford, why would she have copied you in on this email? You said, well, I was looped back in 2017, and so maybe she's copying me again. You were not looped in
Okay.
2017, and now she's copying you in, and that's why I'm asking if you have any sense of why she would now be copying you in.
No, and that's why I think I asked before. I said, was I copied back in 2017? And I thought you said yes. So
I misheard you. I thought you said I was not copied in, and I said yes. So that's why I wanted to bring it up again, just to make sure that we weren't miscommunicating, you and I.
No, I don't know why she copied me on it. I'd be speculating. I'm thinking maybe she was having some difficulty getting the document from him, and maybe that's why I'm being copied on something. Because as you say, as I said before, I typically wasn't copied on things unless they were having some difficulty getting some of the documents that they needed.
Well, the document's attached to
Right.
this email, so that's not the problem.
I don't know why.
Okay. This is approximately 3 months after you received Shillington's reporting letter, the one that we were just looking at from late January. Do you recall if you'd had any discussions about the Tradewin report with anyone from Shillington's after receiving the reporting letter and before this email from Ms. Crawford?
I don't recall. I don't remember.
Turning again to that point, plaintiff's counsel has specifically asked us about friction testing. Were you aware of any other requests in other pieces of litigation involving the Red Hill for requests for friction testing from plaintiff's counsel?
From plaintiff's counsel? No.
Yeah.
No.
So you told us earlier when you're looking at the reporting letter from January that the fact that the trade wind report had not been reported to council, what city council, was not significant to you. I'm paraphrasing your earlier evidence. You didn't note that, or that it wasn't, of interest to you. What about at this point when Shillington's is preparing the affidavit of documents and Ms. Crawford is saying, we're likely going to have to include this report in the affidavit of documents, and you get confirmation from Mr. Moore that the report was not provided to council? Does that have any significance to you?
Historically, it's never whether or not a decision that was made on an operational level, whether or not it was reported to council or not, has not been a material fact in any of my claims experience. So it really didn't jump out to me as being a concern.
Okay. Beyond filing this correspondence, did you review the trade wind report that was attached to Ms. Crawford's email when you received this email in May of 2018?
I may have had a really quick look at it, and I've reviewed it a few times. I can't say that I've read it verbatim even now. It's highly technical, and I get lost in it. It's got such a level of technical expertise.
But you can't recall either way whether you reviewed it at the time or you think you did review it, but just to the extent that you could understand it.
Yeah, maybe just a cursory review to understand what it was about.
Okay. And would that have been consistent with your personal practices to review at least skim documents that are received from defense counsel?
Yes.
Did you discuss the trade wind report and its likely production in the city's affidavit of documents with anyone at Shillington's in and around this time?
I may have had a conversation with someone about them. It's probably because it's something I had never saw before. Pavement, the material, what pavement is made of for roadways, I cannot recall it ever coming up in any other litigation I ever had.
Okay. Do you remember either way whether you had any discussions with Shillington's? I can say there's no emails or traffic to suggest a call. There's no emails in which you're discussing it.
Yeah, no, I don't remember.
Did you discuss the trade wind report with Mr. Moore?
No, I didn't speak to Mr. Moore at all.
What about with Mr. McLennan?
Who? McLennan?
Yeah.
Mr. McLennan? At some point, John McLennan, at some point, I know later on, John McLennan became involved, or he reached out to me. I think it was later in 2018. There were some discussions about it.
Yes. So before those discussions that involved Mr. Sabot and others, just after receiving in May of 2018, and let's say through the summer and into the early fall, did you have any discussions with him about the trade wind report during that period of time?
No, I don't recall any discussions along those lines.
Did you discuss it with Ms. Lazo?
Did I discuss it with Ms. Lazo?
Yeah, it being the trade wind report.
I don't recall.
You had said earlier that you're trying to facilitate to ensure that, again, I'm paraphrasing what you said, but the in-house counsel doesn't need to reinvent the wheel or redo work that external counsel is doing. Did you provide Ms. Lazo with a copy of the trade wind report?
I think later she got one, or she got it on her own, or she got it through Marco Odie. I can't remember. That's why I put defense counsel in direct contact with the client group, because it is very, very difficult when you have the number of claims that you have under your carriage to make sure in every instance that everything is captured across all of the files. That's that's a huge undertaking. That's why I make it very important that the client group and the deponent is responsible for making sure these documents are produced to defense counsel.
My question was about Ms. Lazo, who is
Ms. Lazo.
internal counsel. I don't
Right.
think you put her in touch with external counsel. You've suggested you're going to be the liaison to ensure that she can look at past documents. So did you provide her with a copy of the Tradewin report at this time, again, from May until November of 2018?
Till November. I'm not sure when she got it, to be honest, or when I'd have to look again. I'm really not good with these dates, jumping all over.
We'll get to the emails that I see where she becomes involved again, Ms. Lazo. But I'm asking you if you recall. Maybe let's do this. Did you personally ever give her a copy of the Tradewin report?
I don't recall. I have to look. I would have to look at that. Isn't there's? I don't recall.
Okay. Did you provide a copy of the trading report to anyone at the city in and around this time? So from May of 2018, when you received it from Ms. Crawford until November of 2018.
Until November of 2018. No, I seem to have some distant recollection that I provided somebody something in November of 2018, but I'd have to go look.
Well, we'll get there, certainly. There was some back and forth with you and Mr. Sabot. Ms. Audie is involved. So I'm asking sort of before that period where people are asking you for information and it sort of comes back to the surface, the issue of these pieces of litigation. Before that period of time, did you provide the Tradewin report to anybody at the city?
No, but I do have a recollection about talking about it with Donna, and I knew, and I think she was doing some investigating on her own. But to answer the question, the answer is no, I don't recall giving it to her.
Okay. Commissioner, I'm noting the time, which is 20 after 12. We did take an earlier break, and I'm certainly content to continue to push forward until our usual 1 o'clock break. And of course, Ms. Swaby can confirm. I get the sense that she might need a little bit of a break, and I wonder if we might, just because it's been an hour and a half, it's a long time. To answer questions. And I wonder if this might be an appropriate time to take a slightly earlier lunch break than we normally do. Ms. Swaby,
Sure.
Would that be useful for you, or am I?
No, that's okay. It's just, I get frustrated because I can't remember everything and I wish I could. That's all.
I understand. And sometimes having a break from the screen is a useful thing to get back on track. So I propose that we take an early break or an
Okay,
early lunch.
sure. If it's 20 past 12, that means we're going to be coming back, at 25 to 2? I guess that'd be right.
That sounds right to me. Thank you.
Okay, then let's stand adjourned until 25 to 2.
Commissioner, may I proceed?
Yes, please proceed.
Thank you. Ms. Swaby, we're now going to talk about the events in the fall of 2018. Registrar, can you bring up OD 9A, page 118, please? And can you call out 295 and 296? Ms. Swaby, on October 11th, Mr. Sabot emailed Ms. Edwards, who is in the legal department, and Mr. McLennan to ask, well, as an FYI and a recent discussion. You're not copied on this email, but Mr. Sabot says, also, John, is your recollection the same as mine, that plaintiffs' counsel in recent years have been aware of or requesting information on the RHE studies as a result of some discussions at city committees or the press? And then there's a reference to a blog post from the Local Authority Service, a non-for-profit organization created by the Association of Municipalities of Ontario. As I said, you're not copied on this email. Do you recall if anyone spoke to you about the questions raised by Mr. Sabot in his email chain below? I mean,
I don't recall. No, I don't recall anyone talking to me about this email exchange.
Registrar, you can close this down. And if you could go to page 130, please. You could call it 314 and 315, please. On November 8th, the city received an FOI request. The first bit is just a reference to the receipt of the request, and then you'll see at 315 is the actual request, which is access to reports, memos, drafts, correspondence about friction testing on the Red Hill in the last 5 years, and reports, memos, including drafts or correspondence about asphalt or pavement testing, assessment, plans on the Red Hill for the last 2 years. I know that you become involved at some level in respect of this FOI. Do you recall, did you ever receive a copy of the actual request itself?
No, I did not.
Were you aware of the nature of the request, that it was related to friction testing on the Red Hill in the last 5 years and asphalt and pavement testing assessments, et cetera, for the last 2 years?
It would have been brought to my attention on a general sense, I think in late November when I was approached.
Registrar, you can close this down. If you can go to page 147, please. And if you could call out 344. Ms. Edwards prepared handwritten notes of a conversation that she had with Mr. McGuire on November 12, 4 days after the FOI request was received by the city. I don't think we have any documents to suggest that you either attended this meeting with Ms. Edwards or that you knew about the FOI request at this time, just a few days after it came in. Ms. Edwards transcribed her notes, which is what we're looking at now. And there's also an email below which transcribes them in a more narrative form. So just looking at this again, this is a call between Ms. Edwards and Mr. McGuire. And so I'm going to ask you about this, recognizing these are not your notes. So Ms. Edwards says, Gary sent over info to Diana about 2 years ago. The context of this discussion is about the Tradewind report. So we know that you received a copy in May of 2018 when Ms. Crawford forwarded you Mr. Moore's email. But for confirmation, did you receive a copy of the Tradewind report at any time prior to receiving Ms. Crawford's email in May of 2018?
No. It could very well be that legal and risk get lumped in together all the time. And someone might have thought sending it to Colleen meant it was sending it to me because we're all on the same team. So that may be where that came from, but no, I did not receive it myself.
Registrar, could you close this down just for a moment and go to 345, please? So, pardon me, paragraph 345. Thank you. So here, this is a different, a later transcription of Ms. Edwards' notes, which she made in April of 2019. I'm not going to go to the underlying actual handwritten notes, but you'll see here, she says to Ms. Audie that the report had been sent to Diana and Risk about 2 years previously. And then it goes on. So there's no other Diana in Risk, right?
No.
Okay. Registrar, could you close that down and go back to calling at 344? So it goes on to say there's no report looked at UK STD. There's no STD in Ontario. Report is a bit misleading since not binding. Gary doesn't recall receiving any response. John McClellan is aware. Do you know how Mr. McLennan would have been aware? Were you the source of his knowledge? It's not clear what he's aware of. I recognize it's hard to answer these questions.
Yeah, no, I'm not. I don't know where he received that information.
Did you have any discussions with Mr. McGuire about the trade-in report in the fall of 2018?
No.
Did you ever have discussions with Mr. McGuire about the trade-in report?
No.
Did you have any discussions with Ms. Edwards about the trade-in report in the fall of 2018?
No.
Registrar, you can close this down. And if you go to page 155 and 156. And could you pull out 168, which starts at the bottom of the first page and goes on to the second? So we're now at November 20th, and you receive a copy of the Tradewind report from Mr. McLennan. It says, FYI, the preliminary thought is that this report will have to be released to the requester. Obviously not a good turn of events for any of our RHVE files. You will see an email where I advised Nicole/Ron of 4 files I could find. I said you could provide more information on those files upon your return and advise if any that I might have missed. He mentions you could provide more information upon your return. This is November 20. There are other documents that suggest that you were out of the office during this time. Were you on vacation when this email was sent to you?
I believe so. I think I was away on vacation.
Registrar, could you close this down? And could you call it 370? So you'll see in the excerpted text in the email, the last paragraph says, as stated, this is just my quick search in advance of Diana returning. She is back Thursday. So this is November 20. Thursday would have been November 22. Is that consistent with your recollection of when you returned from vacation?
I don't have a recollection. I would accept it as being true.
Were you checking emails while you were on vacation?
No.
Okay. Registrar, you can close this down. Had you ever spoken to Mr. McLennan prior to receiving his email on November 20, that first one that we looked at, that's at 368.
Have I ever spoken to John about?
Had you ever spoken to him about the trade wind report? Pardon me. Not generally.
I have a vague recollection of talking about friction testing being done, the existence of friction testing. Generally speaking, I think, certainly dating back to, I think we're dating back to 2013, there was some suggestion of, or some inquiries that he might have been receiving, and he asked me at one point if I had, if there was anything I was concerned about with the litigation. And of course, this is, again, it's difficult. I couldn't give you a specific, yes, I spoke to him about the trade wind report in advance of this meeting, but I know that there were some discussions over the years about these articles, the friction testing, and he asked me my input on how the claims were running, and my response would be that they're ongoing. And there was nothing that it was too soon or to be able to tell whether friction testing was going to be a material fact or in relation to the assessment of the legal exposures in each and every one of those particular files.
Okay, and when did you have that in relation to November 20th?
November 20th, I don't believe I spoke to him specifically about the trade wind report until after November 20th.
Okay, so the evidence that you just gave about the specifics of how the trade wind report, how the claims are running and what the trade wind report would impact those, which I'm paraphrasing your evidence just now, but I think that's what you were saying. Did that happen before November 20th?
Well, there would have been, like I said, there wasn't a specific discussion, but just thinking back of my testimony earlier as well, Ron Sabot had an email to Donna Lazau talking about the article, the friction testing. There are previous, so it came up there. I may have had a conversation with him, very, very general about it, that it was out there, he was doing his, but nothing specific. I'm sorry, Emily. I can't think of anything specific before this date about the trade wind report.
Okay. Do you think that you ever actually used the words trade wind report or friction testing report, something that indicated that you actually had some document that you were speaking about with Mr. McClellan?
No.
Okay. So when you returned from vacation, would these emails that you first you received and then you were copied on, would those have been the first emails in which you learned about the FOI request?
Yes.
Did you connect the report where it says the preliminary thought is that this report, attaching the trade wind report, did you connect that to the report that Ms. Crawford had sent you in May of 2018?
I might have gone looking for it or to see when I had it.
My question is, when you opened up the attachment to the November 20th email, did you open it and go, oh, I've seen this before? And you said earlier, when you looked at it, you found it to be very, very technical. You weren't sure when you looked at it, but had you looked at it by November 20th?
Had I looked at it by November 20th, I can't recall. I don't remember.
So you can't recall whether it was familiar to you when you in that you'd already seen it when you opened it on November 20th?
It may have been familiar to me.
But you're not sure either way?
Yeah, I know that we talked about friction testing. Was this the report that talked about it? Perhaps I really didn't spend a lot of time. I guess I'm not sure quite of the question.
Ms. Laura, it might be helpful to take Ms. Swaby to her November 23rd email. That might help refresh her recollection.
It might. I'm going to ask some questions first to try to do that, though. When you received the Tradewinds report from Ms. Crawford, recall we looked at those before the lunch break, and then you received a copy of the Tradewinds report on November 20th. And my question was, when you opened the copy that you received on November 20th, was it a document familiar to you in that you'd already opened it because you'd received it before? Or was it the first time you were looking at it on November 20th?
I don't remember now. I can't remember what was going through my mind when I opened up the email of November 20th and what I looked at when I reviewed it. I can't remember that now.
Okay. Did you have any discussions with Mr. McLennan about what he meant when he said the preliminary thought is that this report will have to be released? And then when he said in particular, obviously not a good turn of events for any of our RHVE files.
I probably wouldn't share the same sentiments as he did insofar as, you know, if it's a producible document, it is what it is, and it should be produced in any event if it's relevant to the litigation. So from my perspective, that's how claims go. You need to conduct, you need to produce all of your relevant documents, and you assess it after you've looked at that and compared it to the facts to the individual claim and whether it's the proximate cause, and then you determine whether or not it's an exposure or not.
Did you have any discussions with him about what he meant by that?
By saying it's not good? No.
Obviously not a good turn of events.
No, I didn't have any discussion with him on that.
So you returned, it seems from the emails you returned on November 22, which was the Thursday. Did you tell Mr. McLennan that you had a copy of the Tradewinds report on that day?
When well, he sent it to me on November 20th. It was attached to it. So you're saying, did I say I already had it?
Yes.
I don't think I did.
Okay. Registrar, can you pull it 370? This is an email. You're still away at this point, and this is the one in which Mr. McLennan says we have 4 significant claims, but that's just my quick search until Diana is back. She will comment on these files and any others I may have missed. And we will come to an email in which you talk about the Tradewinds report, but my question here is, did you provide any of the individuals who are copied in this, Mr. Audie, Mr. Sobo, or Mr. McClellan, with an update on whether those 4 files were all of the RHVP files?
No, I did not. I did not conduct a exhaustive search of all of the Red Hill files.
Okay, so Mr. McClellan's gone looking and has found 4 claims.
Yes.
And he said, this is just my quick search in advance of Diana returning. She's back. We'll be able to comment on these files and any others I may have missed. So you did not go through and determine whether he had missed any?
No.
Okay, did somebody else, to your knowledge?
Yeah, it's my understanding that a more exhaustive search was done by Gavin after capturing more files. And that was it came within the next few months because I understand there was also a meeting with the insurers that came in February. So it was important that they had all of that information by then.
Okay, so, but it looks like it's important that they have the information now for those people who are on this list. Did you comment on these files, these being the 4 files that he had identified?
No,
Did anybody ask you for an update about those files?
no.
Okay.
Well, there was a meeting that came afterwards when I came back from my holidays that we had a discussion about what they were looking for in terms of dealing with the FOI requests. And that was the purpose of my involvement, recognizing that I had claims.
Okay. Did you have more than 4 claims at this point?
In 2018, I would think yes. I don't even know which 4 ones he's referring to in this list. He doesn't identify them.
Okay. Register, can you go to page 158, please? And can you call it 375? So this is an email exchange with Mr. Sabot and Mr. McLennan. And it's Mr. Sabot says, I'll check with Dan, who I believe here to be Dan Bartley. And Mr. McLennan says we should let the insurer chime in. And then Ron says, I spoke to Dan briefly on his 2 claims and let you know that you will be speaking to him. And then this is still Mr. McLennan speaking or writing. Diana, can you please put a call into Terry Shillington as soon as possible tomorrow? Thanks. Do you remember having any conversations with Mr. McLennan about putting in a call to Mr. Shillington, either on the day before you returned from vacation or on the day that you got back from vacation?
I don't remember having a call discussing with John specifically before I called Terry.
I think there'll be an email that will make that clear, which we'll get to in just a moment. On the issue of letting the insurer chime in, who in risk management had the responsibility to update the insurer on issues that arose?
On the individual claims, if it was an individual claim, it was myself, but they'd be apprised. We were both working and there would always be an examiner on the insurer side that would work with defense counsel at the same time as myself. So they would be apprised and kept up to date as litigation moved forward on the insurance. With respect to apprising the insurer, I believe that would be the issue that John was, I think, dealing with on whether or not this Tradewind report had any implications for other files, these files, more files, and hence why the meeting with the insurer in February.
Okay, so even though these were, at least 4 of them were, at least 4 of them were your files, I think that is the inference from Mr. McClellan's emails. You would normally on an individual file update the insurer, but in this case, Mr. McClellan took over the responsibility of assessing when and how to update the insurer. Is that right?
I think he was thinking more of a much broader approach on the issue of the Tradewind report and it not being released and the implications that would be reviewed with the insurer, not just in the context of these claims, but potentially other claims.
Thank you for that extra context. So in speaking in that sort of broad, letting the insurers chime in on the issue of potential claims that could arise, was it you or was it Mr. McClellan who decided when and how to update the insurers in these particular claims that were over which you had carriage?
In these particular claims, there would be defense counsel that was there that would be aware of the, assuming I'm not sure which claims he's referring to. I can only talk about the claims that I was dealing with Shillington's. And I know that there were other claims. I see that there was one that was in-house with Dan. I don't know that I had much contact with him on that, some of the in-house files. They weren't all in my carriage. I know that there were some others that may have not have had very much activity. I'm not sure.
So my
So
question was it you or was it Mr. McClellan who decided when and how to update the insurers on the claims that you did have carriage over?
I would be responding, I would update the insurers, I think Ian, it would depend on the examiner. I update the insurer on the claims that I'm dealing with.
Okay. And was it you who was deciding when and how to update them?
The updates at that point, they're with outside counsel, with defense counsel, who are taking the lead. So they to do the updates to the insurer as they uncover the productions, as they determine the implications of them, as they review it from a legal perspective, that they would be doing the updates.
Okay.
And hence why there was also a request that I reach out to Mr. Shillington about this.
Registrar, you can close this down and if you could bring up 376, please, which goes on to the next page. Ms. Swaby, so this is an email that you sent in reply to the email about the 4 claims, asking you to pardon me, it's in respect of Mr. McClellan's email sending you the try to win report. And this is the first response that we have from you on that day. So it would be November 23, which is the Friday after the Thursday that you get back. Before you sent this response, did you have any discussion with anyone internally at the city or externally about the FOI or the trade wind report?
No, when I came back, did I have any conversations in advance of writing this letter, before writing it, or this email?
Yes.
No, I don't believe so.
Okay. Did you review any documents or emails or notes to refresh your memory before you sent this email?
No, I might have done a cursory search of my inbox in my emails to see if there was something in there that I could jog my memory about the last contact talking about the friction testing.
Okay, so you say this report concerns the RHVE and the link. So just stopping there, by November 23rd, had you reviewed a copy of the trade wind report?
I probably looked at it quickly, skimming it as we talked before, when we talked about Colleen Crawford giving it to me. I may have skimmed it.
Okay, and then Mr. McClellan sent it to you again on the 20th.
Yes.
So you have the copy from May 2018 and you have a copy from November 20. Before November 23rd, you read the report?
I would have skimmed it. What's important to me from my perspective is productions, and that we have them, and to go through it and digest it and make comments and talk about the sufficiency and the implications and what it means. That's not something I would have spent a great deal of time on doing it, recognizing that my primary function is to make sure that they're available, they've been produced, and the lawyers and the engineers deal with it.
What did you mean by the trade wind report being a red herring?
Well, from my it's completely from a claims perspective. It's a claims lens, not a road safety lens. So when I'm dealing with claims, I'm assessing liability in the sense of is it material? Is it the proximate, is it a contributing factor to the overall facts and that gave rise to the accident in question. So each individual claim would have to be assessed based on the unique facts of that case. And whether or not the pavement integrity or what it was made of being a contributing factor. If anything, I was probably very skeptical because in my now I guess it would have been about 25 years in experience, it's never been a topic or an allegation in the claims that we've had to deal with. No one's ever asked us about it before, and we've never had to deal or address that before. So I would have seen it as a bit of a red herring, and depending on in some of the cases, and you know, that's really my candor, you know, what are the causes of various accidents? If an accident happens because a tire blew, or if because someone was driving dangerously or doing an excessive speed, just that's my approach being a claims person, as saying who's really at fault for this accident here. And so that would have been my very honest, you know, reflection on it from a common sense perspective at the time.
So you say, and this may refresh your memory, all of our serious files on the RHBE and the link are for the most part being defended by Shillington, save and except Shirk O'Hare, which is Donna Lizzo, and one being handled right now by Dan Bartley, Kana Menagorantarathian. I think I've said that completely wrong. Does that refresh your memory about the matter that Mr. Bartley had?
Yeah, those would be the ones that, you know, they stood out to me. I think later on we identified a few more. But yeah, that does refresh my memory. Yes.
And the Shirk O'Hare, is that the Hanson and Burnett?
Shirk O'Hare, Hanson and Burnett. Shirk and O'Hare is a different claim. That's on the link.
Okay. And so there's no reference here to the Hanson and Burnett matter?
No. I didn't necessarily capture them all. I would never have expected this response to capture all of the files.
You do say are serious files. So, and I think you said earlier in your evidence that you did not undertake a search in Risk Master to get a better sense of the scope of the RHVP or link files. Is that right?
Yes.
So you're just going from what you have in your memory?
Yes.
You go on to say that Shillington's recently asked about the report, stating that it will have to be produced in the city's affidavit of documents in at least one of the claims. An inquiry did come in from Shillington's concerning this report. The inquiry was referred to Gary Moore, who indicated the report was not presented to council. So what you don't say there is that you actually received a copy of this report from Shillington's. Why don't you say that?
It's important. Why didn't I say it? It's important that Shillington's has it more than it is important that I have it. I don't receive all the documentary productions, especially once council takes it over. And I don't typically spend a lot of time looking at the documents themselves. That's council's job.
You also don't say that Shillington's has a copy of the report or that they provided it to you. You say they asked about the report. Why don't you say that?
Well, I think it's kind of presumed because they say it would have to be listed in the affidavit of documents in at least one of the claims. I would assume that they have to review it to know what it's about and to make the determination where it falls in an affidavit of documents. You'd have to look at it to do that.
Did it cross your mind to provide a copy of the May 4th, 2018 exchange with Mr. Moore and Shillington's to legal services or Mr. McClellan? I
didn't, from my perspective, you know, through my claims lens, again, I keep saying this, but what matters is that we had it for the claims. When we received it would not have been a material fact that I thought I needed to share. If someone wanted to ask me, I would have told them when it looked like when we got it. I would have certainly reached out to Terry, asked when we received it, if someone asked me. But if you didn't ask me, I wouldn't turn my mind to it because it's not something that I considered important from a claims perspective. Claims perspective is make sure we have it. If it's out there, make sure we have it, as opposed to when did we get it? Because litigation runs over several years and we'll see what the implications are of the report, but whether or not it will increase exposure depending on when we received it or not. I hadn't turned my mind to that.
And you hadn't turned your mind to the fact that there was an FOI and that the city was going to have to respond to that? Was that part of your thinking?
Well, FOI requests for documents, I wasn't part of the FOI review or the context or the implications. FOI requests can happen before litigation starts. They can happen during the course of the litigation. And what the implications are for that would be the people that are reviewing the FOI request. And I wasn't really involved in that until November 23rd.
Yeah, and now we're at November 23rd. So
Right.
if you turn your mind to the fact that the city was going to have to respond to an FOI request, and I'll put to you, providing more information would be useful for legal services to be able to respond.
It very well could be, and if they'd asked me, I certainly would have told them about that. From my recollection, the question was whether or not it should be produced or not because of claims privilege, more so than timing.
You say at the bottom of this email, if there is a specific question I need to ask Shillingtons, please advise. Did anyone give you any direction about what to ask Shillingtons?
No, I don't believe so.
You also say, please, perhaps Donna Lazo can also assist. Why did you think that Ms. Lazo specifically might be able to assist?
Because Donna Lazo also had a legal file.
Registrar, you can close this down. And if you can call out 377 and 378 on page 159. So you emailed on November 26th, Mr. Shillington, marking the email as high importance, and you forwarded the email that you and Ms. Crawford had received from Mr. Moore on May 4, 2018. In fact, let's just pull that up. HAM 64140, please. So you'll see on the right-hand side is the emails from May 2018. Ms. Crawford copying you in on the email that we looked at earlier today that had the Tradewind report and her reference to this is now, we are likely to produce a copy of this report in the city's AOD. And then Mr. Moore responds, this report was never reported to council. And then so you take that email and you flip it to Mr. Shillington with the high importance. Where did you find this email chain in order to flip it to Mr. Shillington?
I likely had it in my inbox, probably searching for friction testing, having a vague recollection about it and bringing that to the forefront because now we're meeting in the afternoon. I would have marked it high priority only because we were meeting very, very soon. And so I would have used that as my backdrop to reach out to Terry Shillington.
You said earlier in your evidence that, we'll blow it up for you, Ms. Swaby, so you just don't have to look so closely. Can you, registrar, pull out the bottom half of the left-hand side? I think, Ms. Swaby, this is what you were looking at. And before we get there, I do have one more question. you said earlier that you deleted things from your email once you printed them out. And that's why I'm asking, how did you locate this in your inbox?
Sometimes it's months or a very, very long time before it gets out of my email and into the file.
Okay.
So it could very well be that was the reason why it was still there.
Okay. So you say to Mr. Shillington, I'm meeting with the GM of Public Works as well as the Director of Legal Services and John McLennan of our office concerning an FOI request to release this report. So just stopping there, the GM of Public Works, the meeting with the GM of Public Works and the Director of Legal Services and John McLennan, how did that come together? How did that get scheduled?
I don't know. I assume that was through John McLennan and Nicole Odie.
Okay, and so you have it in your mind that you're meeting with those three people that afternoon on November 26th?
Yeah, that's what I gather from this email, yes.
We'll get to it in a moment, but do you remember actually meeting with Mr. McKinnon, someone from legal, and Mr. McLennan?
I know it's terrible, but I don't remember.
Okay. So you you go on to say, I take it that they do not want to release this report. What was the basis for you saying that?
Well, normally I'm consulted to see whether or not there's claims privilege for the release of it. I don't typically get consulted on FOI requests unless there are claims. And when there are claims, they like to know whether it is subject to privilege, because that would be one of the exceptions for not releasing it.
So that answers why you were involved, but it doesn't answer why you say, I take it that they do not want to release this report. Why did you say that in that way?
Because they were being brought in to look at it, to see whether to release it or not. Why would you ask for a legal consultation if that wasn't what's one thing was to be considered? It might be a presumption. I don't have any information from them directly to suggest that.
Okay, so you don't remember receiving any information from anyone saying we don't want to release this and we're going to meet with legal, for example, to have that discussion?
No.
Okay. Was this the first time that you had spoken with anyone at Shillington's about the trade wind report?
Is this the first time I ever spoke to anyone about the trade wind report?
Anyone at Shillington's?
Other than the emails before about that, where it was provided to me.
Other than emails, but actually like oral discussions. Is this the first time you spoke to anyone at Shillington's about the trade wind report?
Specifically, I don't remember any discussions over the phone about it. I'm not saying it didn't happen. I just don't have an independent recollection about it.
Okay. Registrar, you can close this email, this call out down. And if you can call out the 3 emails on the left-hand side, the 3 top emails. Registrar, apologies, but could you close that call out and just the first 3? So from the very top of the left-hand side down to, yeah, right there. Just so we can call it a little bit bigger. Thank you. Could you move it a little bit more to the middle of the page? Thank you. So from your request to Mr. Shillington to have a conversation, which he says, yes, I'll talk to you soon. Ms. Crawford, Mr. Thompson, and Ms. Shillington then have some back and forth. Ms. Crawford said, this report is listed in our Schedule A productions. We've not served our AOD. And Mr. Thompson says, I can't think of any concern for our litigation except that it is not relevant. The last I heard, the report had not been produced to council. If they decide not to provide it in the FOI, they should let us know so we don't include it in our productions. And then Mr. Shillington says a little bit later, thanks, she's good with our review and will let the others know. Any questions, she will call you or myself. Thanks for the quick update. So that's the back and forth that happens, all of which you're not copied on, but I have some questions. Do you recall having a discussion with Mr. Shillington on November 26th?
I assume I did have a conversation with him. Yes, based on this, that we did have a conversation that morning about the Tradewin report, the fact that they have it where they would consider it to fall in respect to the affidavit of documents.
Do you recall that discussion?
Not independently. I don't have I know that it would have happened that morning, but what the actual conversation was, I can't remember.
Do you recall what you told Mr. Shillington about the FOI and the possible release of the Tradewin report?
No, I don't. I just know that it was subject to a freedom of information request, and that it was going to be requested, it was being considered to be requested or be released.
Did Mr. Shillington tell you that the Tradewin report was not relevant to the Mello Lee Barlow claims?
No, I don't recall that specifically. If anything, it would be more of a discussion about its relevance depending on each of the cases at the time and what we knew about them, the circumstances of each accident, how it arose, and they would be looking at each one of them individually to determine where it goes. I really don't, when I say where it goes, I mean Schedule A or Schedule B from a claims privilege perspective. But ultimately the determination of whether it goes in Schedule A or B or isn't even noted. I know that there are some defense counsel there that are of the opinion that if it's not relevant, they don't need to refer to it at all. But I don't leave those kinds of I don't make those decisions. The lawyers defending the claim do.
My question was specific about whether Mr. Shillington told you that the Tradewin wasn't relevant. Did he convey that view that Mr. Thompson had conveyed to him?
I don't recall that.
And is that to say you don't recall either way, or are you confident that he did not?
I don't recall it either way.
Okay. So then, do you recall what discussions you did have with Mr. Shillington about the implications of the release of the Tradewin report on the litigation that he was retained on?
No.
And is that you don't remember either way?
I don't remember either way.
Okay. Mr. Shillington advised his colleagues that you were good with our review and will let the others know. What information is Mr. Shillington talking about here that you were good with?
To be fair to Ms. Swabe, she has stated clearly that she has no independent recollection of this call. So I don't know if any of this continual questioning about this would be of assistance to the commissioner.
It's always amazing how people can sometimes remember things. So I would like to answer have these questions asked just in case something comes to Ms. Swaby's mind. I am about done with this line of questioning. Mr. Commissioner, you're muted.
Thank you. I was going to say, I think perhaps rephrased not as what does that refer to, but does it recollect or cause her to recollect anything further? The question can be put, and then let's move on.
I think Terry, when he says, is she good with our review and will let the others know any questions, she will call you or myself. Does that refresh my memory? A little bit, but not to the point of getting specifics. I would imagine that he would have told me how this report impacts the litigation on the various claims they were handling based on the information in hand at that time. And I would have accepted that, and that would have been the end of it, and reported back to John McLennan and the others about the information about it being at least Schedule A on at least one of the claims.
Do you recall when you made that report back to Mr. McLennan and the others?
No, I don't recall when. I take it if we had that meeting that afternoon, that information would have been communicated then.
Okay. So there's a back and forth. The part that you're not copied on is about if they decide not to provide it under the FOI request, they should let us know so that we don't include it in our productions. Did you give instructions to Shillingtons at any point to remove the trade wind report from the city's production because of the FOI request?
No. Really, just to provide some context, I think there was the issue of the FOI request being dealt with by John and Deb and the legal team, and I am dealing with the claims, and as I would deal with them in their normal course, and they're reaching out to me for certain bits of information that may or may in fact may not impact the release, whether they release the report. And if Shillingtons had said that the trade wind report is going to be in Schedule A in at least one of the documents or one of the claims, then that information would be communicated over to them. I don't see the claim unless it's privileged, it shouldn't affect how the freedom of information request is dealt with.
So you view the FOI and the disclosure obligations, production obligations in court as just two separate things?
Yes, unless it's subject to litigation or claims privilege, that would be the only time that might be a factor that needs to be considered from my perspective.
Thank you. So you said earlier that you don't remember a meeting with Mr. McKinnon, the Director of Legal Services, and Mr. McLennan.
No.
And we've gone through a few more documents now, including some information you have from Shillingtons, which at some point you've given evidence you would have conveyed. Does what we've gone through, has that assisted to refresh your memory in any way about attending a meeting with those individuals?
Unfortunately, it does not.
Okay. Registrar, can you go close this down and go into 9A, page 407 and 408? And could you call up at page 407, the paragraph starting at 933? So, Ms. Swaby, these are undated handwritten notes that have been transcribed that were handwritten by Mr. Sabot. And he believes that this may have been sometime in, that he would have made these notes sometime in November or December of 2018. And the reason I'm taking you to them is he identified that it's a John. And then what are we telling him? Outside operation, I think, speed, litigation, and then it says risk, DS, 1 or 2, Donna, 2, Dan, 2, Donna has SEMA reports, may not be friction testing. So just stopping there, the DS there Mr. Sabot advised would have been in reference to you. Risk, Deanna Swaby, 1 or 2. It seems from what we've gone through that the numbers there may reference the claims that you had carriage over, recognizing that 6 because you and Donna might have counted the same ones twice, or you and Dan might have counted the same ones twice. So I know this is not particularly instructive to you, but do you recall attending a meeting with Mr. Sabot in particular in or around November 26th?
No.
Okay.
Well, I don't think I met with Ron Sabot.
No?
I don't.
Okay, that's
think I
helpful.
did. No.
Do you remember meeting with Ms. Audie around the trade-in report or the FOI request?
No, unless it was that same meeting in that afternoon with the GM, that November 26th one. And again, I don't remember it. But if there was a separate meeting with Ron and Nicole and myself, just us, I don't think that wouldn't have happened. I don't think it happened.
Well, I'm trying to narrow it down. So I presume, and this is just a presumption, that you didn't meet with Dan McKinnon, the general manager of Public Works, all that often. Is that right?
Right.
And so meeting with him maybe would stick in your mind, even these many years later.
Yeah, that's why it kind of boggles me that I don't remember.
So I'm wondering whether there may have been a meeting that was with Mr. Sabot and or Ms. Audie and or Mr. McLennan, all people who I assume you met with somewhat more regularly than Mr. McKinnon. Is that fair?
Yeah, I don't think I ever met with Nicole Odie.
Okay. And you don't think you met with Mr. Sabot about this issue?
I don't recall having a specific meeting with Ron Sabot on
Okay.
this issue.
Are you confident that you didn't meet with him on this issue?
Well, he was already meeting with John, and would there be another meeting with me? I doubt it.
Or a meeting with you and John together?
Yeah, I don't remember anything like that.
Okay. And so is that to say you're confident that did not happen, or you just can't remember either way?
I don't remember either way, but my gut tells me it didn't happen. So take it for.
Okay. Registrar, you can close this down. So Ms. Swaby, we have, in fact, you can leave OD9 AF. We looked at a number of emails that you sent or received in relation to the FOI and the possible release of the trade-in report just since after lunch. By late November, sort of after this period, the number of emails on which you are either an author or recipient seems to decrease fairly significantly as it relates to this issue. They're a bit more sporadic. Is the drop that we see in the inquiry on relevant documents from late November, is that consistent with your recollection that you had less involvement after this somewhat busy period of emails in late November?
Yes, I don't, like I said, I rely heavily on email exchanges and communications for the purpose of refreshing my memory. And I would have to answer yes, that it did drop off. They came to me, I was included for the specific purpose about the claims and the issue of claims privilege. I gave them, there would have been a meeting, as we see, we provided that information. And then it wouldn't be surprising to me that would drop off, because they're separately dealing with the freedom of information request outside the claims realm.
Okay, so just closing up that issue. Mr. McLennan had asked you about claims. He'd asked you about speaking to Mr. Shillington. We don't see any email communication from you reporting on those matters. And I think I hear your evidence to be that you believe that there must have been a meeting. Is it fair to say that you would have not let those items that Mr. McClellan asked you to do go unreported to him?
Well, the issue with respect to the number of claims out there, we likely didn't have that information in hand for November 26th. But I believe a more exhaustive search did come after that. And I'm not sure about the urgency of the number of claims. Again, the number of claims and how many are out there may or may not impact the FOI request and whether or not it should be reduced, should be produced or not. I'm not sure that that's, it's good to know how many claims you have out there, but I don't know that that's a deciding factor whether or not you release the information or not.
My question was really, given what we see coming from your boss to you and that there is no email response back to you, knowing your practices and you as you do, would you have let those responses go unanswered?
Well, if he asked for them and he doesn't have them yet, if they went unanswered, it was probably because it was a really busy time and I couldn't do that. I'd have to go to Gavin as well as he would have to go to Gavin in order to get an exhaustive search done. It hadn't got done yet, neither by himself or by myself by November 26th, but it did eventually get done.
Well, the part about Mr. Shillington's and talking to them, that's a different issue. And
Well,
I'm going to suggest to you that if you didn't respond by email, you either didn't answer them or you updated Mr. McClellan orally rather than by email. Which do you think is more likely?
The response from Mr. Shillington about whether it would be on Schedule A or so forth, providing that information?
Yeah, Mr. McClellan asked you to contact Mr. Shillington, and you did.
Yes.
And there's no email that you updated Mr. McClellan about that. And so I can only see two options. You either never updated Mr. McClellan or you did it orally. Which one do you think is more likely?
I would have done it for the purposes of the meeting in the afternoon, orally, yes.
Okay.
With respect to the number of claims and whether I had all the information for that afternoon about the number of claims we have, that likely wasn't done or communicated by that time of that meeting took place.
Thank you. Registrar, can you go to 208, please? Sorry, page 208. And if you can call up 489. So this is just a reference in the overview document. Doesn't have a lot of information here, but on December 7, Mr. Marco Odie was examined for discovery in relation to the Hansen and Burnett litigation, which arose from the motor vehicle accident on the Red Hill. That accident occurred in 2015. And this is one of the cases that Ms. Lazo had carriage over, you'll recall. Yes?
Yes.
This is internal legal counsel. Would you have expected to be advised in advance of the examination for discovery that it was about to occur?
No.
And you'd expect an examination report after it occurred?
At some point, yes.
Okay. Would you have left it to Ms. Lazo and Mr. Odie to confirm the contents of the affidavit documents?
Yes.
And to prepare for the examination for discovery?
Yes.
Prior to receiving Ms. Lazo's examination report, which we'll get to in a moment, were you aware that the Tradewin report, you were aware, pardon me, the Tradewin report was listed in the AOD for that Shillington's had carriage over, given those emails with Ms. Crawford?
And normally I wouldn't know those finer details, but because we specifically asked, I knew that in that case, yes.
Okay. And here, did you specifically tell Ms. Lazo about the Tradewin report so she could assess whether to include it in the Hansen and Burnett AOD?
No, I didn't. The expectation is that she's reviewing this with Mr. Odie.
And the expectation is that Mr. Odie has a copy of it?
As a copy of
The Tradewin report.
Yes.
That's the presumption that's built on Ms. Lazo talking to Mr. Odie about it, right?
Well, and he is our representative, so it's his responsibility to make sure that everything that's relevant is produced.
Okay. And you don't have any role in ensuring that a city representative meets that obligation?
No,
Assist him with that?
no.
Registrar, could you close this down?
I should say only if council knew there was something and they weren't getting something and they asked me for my help to get it.
Right. I'm not going to take you into the examination report. I believe you've seen it to prepare for today's examination. I'm just interested in, after you reviewed the examination report, did you provide a copy of the trade wind report to Ms. Lazo for inclusion or for her information?
I don't recall. Probably, I don't recall.
Okay. We looked at an earlier email where Mr. McLennan was speaking about how both Ms. Lazo had a case and also Mr. Bartley had a case, the case name that I completely mangled earlier. Did you take any steps to advise Mr. Bartley of the trade wind report after you received it in November?
No. I do believe legal services did have the report though, because that was part of the review that came later. I think there was a large documentary review.
Can you be
But
more
no,
specific?
when David Bogosian was reviewing it and providing an opinion later. But did I give Dan Bartley the trade wind report? No.
Turning to Mr. Bogosian, Registrar, can you go to 214 and 215 of OD9A? Registrar, OD9A 214 and 215. Thank you. Registrar, could you call at the top of page 215? So this is taken as an excerpt from Mr. Bogosian's retainer letter that he was preparing in December. In fact, on the same day that Mr. Odie was examined, December 7th. Did you have any involvement in setting the scope of Mr. Bogosian's retainer?
No.
Did you know anything about the scope of his retainer in December?
No, I didn't know that David Bogosian was being retained.
When did you learn that he was retained?
After.
In January?
Yes, until I think I learned of him after, when I received his report.
Okay. And is that the report? We'll get there in a moment. A report that Mr. McLennan sent to you for review?
Yes.
Okay. Registrar, you can close this down. We anticipate that Mr. Bogosian may give evidence that at some point after he was retained on December 7th, you and he spoke about, you and he were speaking about other files that Mr. Bogosian had with the city. And in the course of that discussion, the Red Hill came up and you had a brief discussion about Red Hill collisions, sort of a thumbnail sketch of the other or the matters that you had under your carriage, but that the trade wind report didn't come up during this discussion. It was sort of a high level discussion about Red Hill collisions and litigation. Do you recall providing that information to Mr. Bogosian?
No, I don't. I don't recall doing it. It doesn't mean it didn't happen, but it could very well be David Bogosian was on other files as well. And so I did have conversations with him from time to time about some of our litigation.
Okay. Registrar, could you go to page 287 and 288 of OD9A? Registrar, could you call out 669 to 671, please? So I think you said before you got a copy of the Bogosian report forwarded to you. So this is on January 8th. So after the holidays. And this is really the sort of next email from, from that series of emails we saw in November. Is that consistent with your recollection that you didn't have much to do with this case for that period of time? Late November to mid-January?
That makes sense.
Okay. Mr. McLennan asks you to read it today if you can and give me your thoughts. And so was this the first indication to you that Mr. Bogosian had been retained for some purposes relating to the Red Hill?
I don't remember. Sorry, what was the question again?
Was this your first indication that Mr. Bogosian had been retained for some purposes relating to the Red Hill?
I believe so. I didn't retain him. I don't know exactly. Like, I know now that he was returning back in December. No one spoke to me about retaining him or whether they should retain him. I don't recall any conversations about that. Whether I knew he was retained before I read this, somewhere in that intervening period, it could be, but I don't remember. So this is really the first time for me that I can recall David's involvement. But like I said, David may have talked to me in between, but I don't remember.
This email from Mr. McLennan suggests to me that there might have been a conversation in advance. He said, here's the Bogosian opinion, which implies that you know about what the Bogosian opinion is. Do you recall having any discussions with Mr. McLennan about this, about the Bogosian opinion before he sent this email?
I don't. I suspect I might have said, why did we retain Mr. Bogosian? We have Shillingtons, but because that's still something I would have thought we could deal with it through the claims litigation, but I understand it's an FOI request, it's separate. So that would have been the extent of any conversation I had with him in advance.
Registrar, can you go into HAM 26043? I think I've given you the wrong doc ID. Let's try that again. HAM 62043. Thank you. Ms. Swaby, you're familiar with this document by this point, right?
Yes.
Registrar, could you pull up the next image as well? Thank you. So you'll see even just from the overview, there's a number of documents that Mr. Bogosian says that he looked at, including a 6-year performance review by Golder. Had you seen what we call the Golder report by January 8, 2019?
Had I seen the Golder report by January 2019?
January 8th, the day that you're reviewing Mr. Bogosian's draft opinion.
I can't recall. I don't remember. I believe there was a document brief that was given to David Bogosian. And I'm not sure if these documents were attached to his opinion letter or whether, I know at some point I saw a binder or a Surlock's bound brief that was provided to David Bogosian. Whether I read that in context with this opinion, I can't say for sure. I think it's more likely that I just honed in on David's comments in relation to liability exposure.
I know that there was a documents prepared in the context of the FOI that you later provided to the insurer. Is that what you're thinking about, or the Surlock's bound brief that was sent to Mr. Bogosian? Can you give me?
Yeah, that's a good question. I might be mixing them up, to be honest.
Okay. So I think your answer was that that you don't remember whether you saw the Golder report with this draft opinion or before.
Yeah, I don't remember.
Okay. There's also a reference to the RHVP detailed safety analysis by SEMA in 2015, a email about testing results from Golder in November of 2018, and some references to some appendices that are collision countermeasures, and then a draft roadside safety assessment by SEMA in 2018. So for those things, had you actually seen those SEMA reports?
I may have. I'm not sure. When I read this report, I doubt I looked at all of the supporting documentation or went to look at them before I reviewed David's opinion. I'm fairly certain I would have read David's opinion.
Okay. Registrar, you can close this down. Can you go back into OD9A? Page 288, please. And can you pull out 670 to 671? So you say David's opinion is consistent with mine as to friction testing completed as there is no industry standard in Ontario. Stopping right there, there's no industry standard in Ontario. What information was the basis for you? What was the basis for you saying that? Was it Mr. Bogosian's opinion or some other source?
It would be, I think it's in David's opinion. I'm not sure now at the time whether I don't know that I would have gone back to the Mello report at that point. If there is no industry standard in Ontario, that means it's that's a big criteria that we take into consideration from a legal exposure, whether or not you're meeting a standard from a legal exposure, not from a safety concern, but from a legal exposure.
I understand. My question was quite specific on what the source of that information was for you. If it was Mr. Bogosian's opinion, or if you had some independent source of knowledge about industry standards in Ontario relating to friction.
I may have had some background information in my head concerning pavement testing, whether it be through reading. I'm not quite sure.
Do you think you did some reading on friction standards in Ontario?
No, I mean, I think there was some newspaper articles as well about provincial standards or industries. I can't remember, to be honest. I can't remember where I got that information.
Okay. It is in Mr. Bogosian's opinion, to be clear. I'm just understanding. I'm
Okay.
trying
All right.
to ask if you had an independent place that you knew that.
No, if I sat and read David's opinion right now, I would say, okay, then it came from David's opinion. Whether I knew it somewhere else, I guess the answer is no. I don't have a recollection of that.
Okay. Mr. Glennon forwarded your response to Mr. Sabot, and he says Diana's thoughts are consistent with mine. And I think it's incumbent on us to bring in JLT. So just stopping there, JLT is an insurer, is that right?
Yeah, the broker, a broker for the insurers.
Okay. And they get brought in later in the piece in February 2019. Do you recall being involved in discussions with the broker and insurers after the public release of the Trade-in report?
I do have a recollection of a telephone conference call.
Do you have any recollection of being involved in any discussions with the broker or the insurer before the Trade-in report was publicly released? in
No.
February? No?
No.
Are you confident that you were not involved in any of those conversations before
No.
public release?
No. Yes, I am confident.
Okay. Registrar, could you close this and go to HAM 62042? So this is an email. So you get a flip of the Bogosian opinion, and the next day you send it to Donna Lazo. It just says FYI. Had you spoken to Ms. Lazo about the Trade-in report prior to sending this draft opinion to her?
Had I spoke to her about it, I may have. I may have.
FYI seems to be a little general if she doesn't know anything about the Trade-in report. You'd agree?
FYI is general if she doesn't know about the Trade-in report.
It's just saying FYI seems like a pretty general email if she, and maybe confusing one if she doesn't know about the Trade-in report in advance of this. Would you agree?
It would be confusing if she didn't know about it. I assume, I would think she did know about it.
Okay. Do you remember speaking to her about it?
I don't recall. I recall probably speaking to her about the ongoing litigation, the fact that she has a claim and Shillington's has one, and we have discussions, informal discussions from time to time. And I would have just been sharing this information with her so that she was aware of David Bogosian's opinion on liability.
Okay. So I understand the general discussions, and I understand, I think your evidence on why you sent her this opinion so that she would be aware. Just so the record is really clear. Before this, had you sent her a copy of the Trade-in, or had you given her a copy of the Trade-in report?
I don't know. I can't remember.
Did you know that she was aware and had a copy of the Trade-in report from someone, if not you?
I don't know. I don't know offhand.
Okay. Why did you send this to her and not to Mr. Bartley?
Probably because this litigation was very active and I didn't, the other litigation with Dan Bartley, I don't think we'd had any recent conversations about it.
Okay. Do you recall having any discussions with Ms. Lizzo after you sent the Bogosian report to her?
I'm sure we did have some discussions, but I don't recall them.
Registrar, you can close this down. The version of Mr. Bogosian's opinion letter that you received was a draft. It was dated December 13th. The Inquirer also received a final version of his report with some revisions dated February 4, 2019. Did you receive a copy of the February 4, 2019 opinion letter?
I don't remember.
On January 23rd, 2019, there's a closed session of council at which council received an in-camera presentation from City Solicitor Nicole Audie, in which they were given basically a heads up about the existence of the Tradewin report and the FOI. And then 2 weeks later, on February 6th, staff were presented with a series of reports relating to the Red Hill in a closed session. And then following that closed session, there was the public release of the Tradewin report, including a press release. Were you involved in any of the preparation for materials for the council meeting on January 23rd?
No,
What about the preparation for the meeting on February 6th?
no,
Did
I
you
wasn't
review-
involved.
Did you review any of the materials that were presented to council? There was a number of reports, including a legal services report,
No,
and you didn't attend either of those meetings.
no,
Did you attend the open portion of the meeting on February 6th?
at the meeting on February 6th with,
It was a GIC meeting.
oh, no, I was not involved in any presentations to committee or council or assembling the documents or the presentation in any form.
So on February 6th, there is a press release that goes out saying that the Tradewin report exists and that it will be released. I am paraphrasing. Prior to, and that press release is circulated to all staff and it goes to the media quite quickly. Prior to this release, were you aware that the Tradewin report was going to be publicly released?
No,
Registrar, can you go to OD 10A, please? Page 46 and 47. And if you can call it paragraph 96, please. I'm raising this because I think I might have spoken earlier and said that there was two bound briefs of FOI records that you may have had involvement given meetings with insurers. I actually think it was in respect of this discussion with Shillington's. I think I misspoke. So on February 7th, this is after the public disclosure, you forwarded the press release to Mr. Shillington and Mr. Thompson, and you said, please don't speak to the media. And Mr. McLennan had said, please don't speak to the media in his email. I have two bound briefs of FOI records that were released. I will have them sent to you this week via courier. So is that, when you were talking before about the Surluck bound documents in relation to Mr. Bogosian, is this what you were thinking of?
This could very well be it.
Okay. Do you recall when you received the two bound briefs of FOI records?
It would have been somewhere between that December and February. I couldn't tell you when.
Okay. Do you remember reviewing them when you received the two bound briefs of FOI records?
Not in detail. It was just, I just knew that they were compiled for this purpose and it would be good to share it. So I don't think I would have reviewed it tab by tab.
Why were they sent to you? The bound copies.
I don't know. I might have asked for it just to make sure that Mr. Shillington had everything that was in the FOI review. But I don't have an independent recollection.
Okay. Registrar, could you bring up HAM 6? Do you?
I think it might be 62271.
I think it's 62270, which is what I meant to say.
Okay.
I might not have said the last zero. Apologies. But thank you, Ms. Hale. So this is February 13th. Registrar, could you pull out Mr. McLennan's email just to make it a little bit bigger? The second email. Yeah, thank you. So this is copied to you. You're in the to line, but it goes to M. Callahan at JLT Canada and L. Papadopoulos at Pearson Dunn. So Pearson Dunn is the broker, is that right?
The city's broker, yes.
And JLT, is that a broker or is that actually an insurer?
Yeah, they're a broker too, on behalf of the insurers. And Linda Papadopoulos is the city's specific broker to help with the securing of insurance and with ongoing day-to-day insurance inquiries, needs, whereas JLT is really the broker that we deal with on behalf of the insurers. So there's QBE and there's Lloyd's, and JLT manages that program.
Okay. Mr. McLennan refers to a conference call with a general agenda. He says, do you recall, did you attend that conference call that would have been on the 14th of February?
I do have a vague recollection of being in on that call.
And did that call generally follow the agenda that was set out here?
As far as I can remember, yes.
To the best of your recollection, did JLT or Pearson Dunn know about the existence of the trade room report before this conference call that you attended on the 14th?
Did they know about the trade wind report before this call? I'm not sure. I assume so.
Sorry, I should have been more specific because of course they planned the call the day before. So it does say conference call Red Hill Valley Parkway. It's now public information as of February 6th. Let me try to rephrase my question to be more precise. To your knowledge, did the folks from JLT and Pearson Dunn know about the existence of the trade wind report before the trade wind report was publicly released?
Before it was publicly released. I don't know the answer to that.
Okay. Registrar, you can close this down. And if you can call out Ms. Swaby's email at the top. So on the 14th, this is at 7:50 in the morning, you say, I'm working from home today. If you want to discuss anything in advance of the telephone conference, give me a call. I didn't have a chance to brief you on my TC with Terry and David. Do you recall meeting or having a call with, I think this is Terry Shillington and David Thompson before the 14th?
I recall my conference.
Do you recall having a conversation with them?
I'm sure I did have a conversation with them to probably gather some information for the purposes of the meeting with JLT.
What do you remember about that call?
I don't remember the call now, but I'm trying to think what I would have asked for. Just their whether or not their continued assistance or would be required to navigate forward with claims or potential claims moving forward, I would imagine.
You don't remember the content?
No, I don't.
Okay. Registrar, could you close this down and go back into 10A, page 65 and 66? Oh, and I'm sorry, before I move on, that last document that we had up, it's HAM 62270, needs to be marked as the next exhibit, which would be exhibit 184.
Noted, Council. Thank you.
Is it 184 or have I got that wrong? It's 185.
No, it's 184. Thank you.
Thanks. Can you bring up, call out 150 to 152 over those two pages, please? I just bring these up at the same time, Ms. Waby. So on February 14th, you forwarded Mr. McLennan a copy, an email chain between you and Mr. Moore and Ms. Crawford, in which Mr. Moore circulated a copy of the trade room report to Ms. Crawford in 2017, and then Ms. Crawford flips it to you in May 2018. So we've gone through those a couple of times today, and you say, just an FYI, as shown below, the public could have accessed this report long before the recent media attention it's received. That said, I'm not sure we should be seeing an influx of claims coming out of this. Arguably, those claims should be dismissed. I'm sorry, I think I misspoke here. That said, I'm not sure we should be seeing an influx of claims coming in after the applicable prescription dates. Arguably, those claims should be dismissed, you say. So just stopping the prescription date, that's the limitation period. Is that right?
Yes.
And was this the first time that you had had told Mr. McLennan that you had received a copy of the trade room report in May of 2018?
Is this the first time I would have told him that? I don't know. It obviously came into my head with this being all of the issues around it. And I was always of the view that, if you put, historically, I was always the view, if you want something, you do an FOI, you submit it. And if you ask for it, you should receive it. In my mind, it was, look here, dating back, this issue's raised now, but look at how far back this goes. And if you asked for it, you got it, and here it is. That was the context of that email that I sent. Had I told him about it before? Likely not, because I'm really looking at things through the claims lens.
Okay, so your evidence was that on May 14th was the first time you told Mr. McLennan that you had received a copy of the trade room report on May 4th, 2018.
May 4th, 2018. Sorry, what was that? You said something about May 4th, May
4th, 2018.
Yes.
Do you
May
need
4th, 2018. I had it here and I said, here, look, I had it back then and I'm forwarding it to you now. I missed the first part of the question. Sorry.
That's okay. I can restate my entire question. So February 14th, 2019 is the first time that you told Mr. McLennan that you had had a copy of the Tradewin report that you received on May 4th, 2018.
It was the first time I told him I had it?
Yeah.
Probably, yes.
Okay, thank you. Commissioner, I'm looking at the time, it's 3:15. I would like a moment to look at my notes to make sure I have nothing else. I'm quite close to the end of my examination. And I'd suggest I'd be content even to take a 10-minute break, confer with counsel about the remainder of our day, and then finish up my exam.
Good, that's fine. Let's take a 10-minute break and we'll return at 25 past.
Thank you. Registrar, could you put us counsel into a breakout room, please? Commissioner. May I proceed?
Yes, please proceed, Ms. Lawrence.
Thank you. I've reviewed my my notes, and I realized there was one document that that I raised with Ms. Swaby and did not mark it as an exhibit. It is HAM 64296. And I've asked that that be marked the next exhibit, which is 185.
Thank you, Council noted.
Thank you. I have no further questions for Ms. Swaby. I understand that the MTO and Golder also have no questions for Ms. Swaby, and that the City of Hamilton may have some brief questions.
The city has no questions for Ms. Swaby. Thanks.
No? Well, then, Ms. Swaby, thank you very much for attending today. You're excused. And council will stand adjourned then until 9:30 tomorrow morning.
Thank you, Your Honor.
Okay, thank you. Have a good evening, everyone.
You too. Bye.